the illustrious Senator Waters to introduce SB 11. Welcome, Senator.
Thank you, Mr. Chairman, and members of the member of the committee. Good morning. It's good to see you. I'm introducing Senate Bill 11 relative to African American burial grounds. By way of background, this may be familiar to some of my colleagues. This bill we worked on last year, and with some good suggestions and changes from Senator Guida, we passed it on consent in the Senate. Went over to the House, and Resources, Recreation, and Economic Development, which was not familiar with New Hampshire burying ground laws, decided to study it over the summer, and it was a very good study process. And they recommended a couple of changes, and then recommended unanimously that it be refiled for legislation. So that is what is before you today, and I'll talk a little bit about the background here as I go through the bill. But primarily, as it says in the purpose statement, New Hampshire recognized the importance of preserving African American grave sites, markers, and associated archaeological materials, fencing, gates, faunal materials, grave offerings, and decoration of other materials. And wherever such sites are located, the state supports efforts to document and preserve them and to support efforts to identify descendants and descendant communities. Now, much of what you see before you actually is what already exists in state statute about burying grounds, in that if a burying ground is known, or if one is discovered and there are needs to disturb the graves or move a burying ground, or if one has been inadvertently disturbed in excavation, that we have procedures that are followed for these. What the bill intends to do, however, is to add just one consultation process here, that if a grave can be identified as containing remains of someone who was born in an African American born in the period of American slavery, then there ought to be consultation with the descendant community if you cannot find lineal descendants. Now, given the situation of the social death of slavery, as it's called, it's very, very difficult to find descendants of any of the individuals there. So it designates here a descendant community, which should be consulted for that, and names the New Hampshire Division of Historical Resources to make those kinds of connections to the local cemetery trustees or municipality or the property owner on which surrounds such a site would have someone to be able to talk with and talk about the appropriate documentation and disposition. The other part of another part of the bill tries to address the fact that there were, frequent removals over time. Without going into too much of the history, part of the focus of this bill recognizes the fact that these folks who were enslaved had no choice over their burial or disposition of their remains, and they were often done in ways that did not recognize their personhood. And then very early on, in the late 1700s, the practice of grave robbing for use in medical school, Dartmouth, the medical institution, and others, and there was a lot of agitation about that. Eventually, some laws passed about grave robbing for use. And then in the 19th century, there was a kind of a great effort to differentiate among the races and prove racial inferiority for people of African descent, so that bones were dug up to measure skulls and to put on display, and large archaeological collections of remains were formed as well. And then also oftentimes grave decoration stones and other things were removed, and by souvenir hunters or sometimes well-meaning historical societies, but inappropriately took these kinds of remains as well. So this means, in some ways, to address that issue. And I will note that this is something that New Hampshire has a lot of history with. Perhaps people are most familiar with the rediscovery of the African burying ground in Portsmouth. Perhaps a couple of hundred people buried under a street in Portsmouth, and the sewer project unearthed the graves, and the city worked with the descendant community and find a means to appropriately and respectfully recognize that and memorialize the folks who were there, and to rebury appropriately in consultation with the descendant community the graves that have been removed. I will mention that I would think there may be 100 to 200 such burial sites in New Hampshire. People were enslaved in the state from 1645 until it was abolished in 1858. We have some rather extraordinary sites. I will mention Ona Marie Judge Staines, who escaped from enslavement in the household of George and Martha Washington from the president's house in Philadelphia, made her way to Portsmouth, was hunted for decades by Washington and his descendants to try to kidnap her back into slavery, and so she fled out to Greenland, New Hampshire, and had a house site there with her husband and then her daughters, and her burial ground is out there in the woods now underneath a snowmobile track. And this is a site of extraordinary historical importance that, the folks down in Mount Vernon and Philadelphia commemorate Ona Marie Judge. Her story is told in a book, Never Caught. And she gave some very late interviews in the 1840s when she would have been subject to recapture, even as an old woman. I'll mention, Samson Battis in Canterbury as well, who fought in the Revolution and secured his freedom. He had about 11 children. One of his daughters had 18, and yet Canterbury never listed more than 5 African-American people in their census. His grave is marked with a Revolutionary War stone, but his grave was placed in the cemetery down in a swampy area, and thus is kind of endangered from the neglect of that site. So this is a story throughout New Hampshire. The Black Heritage Trail of New Hampshire and local historical societies are rediscovering these sites. They're placing monuments, trying to repair and do them. So the last section of the bill says that if New Hampshire institutions have such collections, archaeological collections, remains, bones, whatever, that they should make a good effort to determine what is there and then find ways to appropriately respect and, if necessary, if desired by the Senate community, rebury those items. And much of this act is patterned on what we also do for Native American remains. The Native American Graves Protection and Repatriation Act outlines similar processes here of dealing with the descendant community. Please do note that I do have on page 1 at the bottom there that if it turns out through DNA analysis that one of the any of the remains do have Native American DNA, then at that point, by federal statute and by state statute as well, NAGPRA provisions would have to kick in. I would like, Mr. Chairman, to make one slight change on line 32 on page 2.
Yep.
After hearing from New Hampshire Historical Society and other historical societies who are quite willing to undertake this. They want to do the right thing, but they have rather vast collections. So I'd like to insert on line 32, after the word shall, make reasonable efforts to inventory. So it would read, research institutions, museums, historical societies, and other collections shall make reasonable efforts to inventory. And I think the reasonableness standard is good there and makes it much more feasible and doable.
What about line 35? It says shall consult descendants, but what if you can't find the consultants? Shall make reasonable efforts? Would that work?
Well, this is similar to the other places there, and if they can't find, as I said, highly unlikely to find descendants, but then they can just ask the, as outlined in the bill, they can ask historical resources to most likely be the Black Heritage Trail of New Hampshire, but it might be another group.
You're just worried about it putting a wrinkle in them, stalling things out. If they can't find a descendant or something to that effect, that's
yeah. Well, the descendant community. Yeah. So they would follow the process. They'd ask the historical resources to put them in touch with folks who do this kind of work.
Okay. Nick, do you have that on line 32? Yes, I do. So could you read that back to me? What the senator just said? Thank you.
And if I may, just in conclusion, Mr. Chairman, having mentioned the Negro Burying Ground in Portsmouth, one of the ironies about those burials there was one was Primus Fowl, who worked for the New Hampshire's first printer, and was really quite noted in town as a poet, as an able typesetter and a leader of the black community. And when he died in 1791, his epitaph read, "Now he's dead, we sure may say of him, as of all men, that while in silent graves they lay, they will not be plagued again." Well, of course, a backhoe and a sewer project put an end to that wish. But I think that, not to make light of it, but we really can now afford these people the respect in death that they may not have had in life.
Where was this, in Portsmouth?
Yeah.
Yeah, that's my grandson has, actually, my nephew owns Portsmouth Printing.
You ought to, when you're down there, you ought to go take a look at
Yeah.
the monument there. It's really extraordinary. Yeah.
Interesting.
So thank you, Mr. Chairman.
Thank
Any
you.
questions? I'd be glad to
Senator
entertain.
Bertzel. And seeing no further questions, thank you very much for your testimony, for bringing the bill forward. And we have Reka. Is Reka? Reka. I apologize. Reka. And it's Mendelvan?
Mahadevan.
Of course. My apologies.
No worries.
You're very welcome to speak.
Thank you. My name is Rekha Mahadevan, and I'm a senior in high school. I'm an intern and tour guide at the Black Heritage Trail of New Hampshire and the vice president of the NAACP Youth Council. I'm here to strongly support the passage of SB 11, African American Burial Grounds. In 2018, when I was 13 years old, my town, Madbury, New Hampshire, celebrated its 250th anniversary. My mom and I went to find all kinds of booths about topics ranging from quilt making to the Revolutionary War. Tucked in the back of a tent from the Madbury Historical Society was a small white binder that held information on our town's oldest buildings. It was in that book that I first found out about the African American gravesite in my hometown, completely forgotten and neglected. My mom and I drove by the gravesite to find it almost buried in leaves and mud with field stones as headstones. It had no markings or monuments to recognize the lives of the people buried. If one did not know about its existence, they could easily walk through without knowing anything was there. Put it simply, I thought this was not only heartbreaking, but outright unfair. Madbury has numerous other cemeteries kept in pristine conditions, yet for some reason this one was left behind. I decided that I wanted to build recognition for not only this site, but for all the African American history in my area. I eventually learned that this site is most likely the graves of the children George and Mary Hall, George Jr. and Elizabeth, and possibly Mary Hall herself. The family was buried in 1868 when an illness sadly took their lives. New England has been known to be the whitest part of the country for large portions of its history. However, referring to the area in such a way effectively erases its rich African American history, through enslavement, the birth of the nation, and the civil rights movement. This project has helped me learn the importance of recognizing diverse history in my area in order to break down the narrative that people of color have had no significant contributions to our town's success. This is why preserving African American gravesites like the one I researched is so important. Being able to diversify history ingrained in all of our New Hampshire towns will, over time, help us celebrate the history of people of color. Thank you.
Well then, questions from the committee. Senator Waters.
Thank you, Mr. Chairman. And thank you so much for being here and for testifying and your extraordinary work on your projects. And my question first is, how's the response of Madbury to kind of coming to understand the research and the significance of the site that you have identified?
It's been a little bit difficult in terms of getting any physical monument up at the time because the gravesite is on private property, but I have been working with the Black Heritage Trail of New Hampshire to spread the information in other ways. I'm working on a video that's about the site to be published on the Black Heritage Trail website, but yeah, I'm still in communication with the property site owner.
If I may follow up, and you mentioned the private landowner, and since the burying ground actually is not owned by the surrounding landowner but by the descendants, and that's why our state statute says that yes, there is a right to have access to such thing, but it needs to be done with the cooperation of the surrounding landowner, and that's a good way to recognize that person's rights, but also the rights to do your research.
Mm-hmm. Thank you.
Thank you.
So Rekha Mahadev.
Mahadevan.
Is that right this time?
Yeah.
All right. Well done. Thank you very much for your testimony.
Thank you.
I don't have anybody else to speak on this. Does anybody else want to speak on this at all?
from up here, if I got in my testimony, that we do have an email that we received today from Ben Wilson, Historical Resources, affirming their willingness to work on this, and there's something they're very used to doing with graveyards, and we have a Preservation Alliance letter of support as well. So, thank you, Mr. Chairman.
All right. Put that in permanent record. And seeing how there's nobody else, we will close the hearing on SB 11. And I think we can go right into the next one, right?
Yep.
So is anybody signed up for the next one? Perfect. All right, thank you very much. Yes. I want to see if I can break and get him first. Yeah, I don't know if send Archer so we can't put it on consent, but we'll just get it out there. Yeah, I'm sure Senator Waters will. All right, let me get this out. Sorry for holding me up. So I recognize Senator Waters for our next bill, SB 13, FN.
Thank you, Mr. Chairman. I'm Senator David Waters, District 4, introducing Senate Bill 13 relative to recovery of search and rescue expenses. This bill is at the request of the Fish and Game Commission to permit the Director of the Division of Motor Vehicles to suspend or revoke the driver's license if that driver has failed to make payment to the Fish and Game Department for the reasonable costs of a search and rescue response for which they are found to have acted negligently. The current law allows Fish and Game to notify DMV of such non-payment and to request a suspension. So that's an existing statute. However, there is nothing within the DMV laws that permits them to carry out such a suspension. This proposal then would add language to that statutory area to allow that. Senate Bill 13 also tweaks existing language so that Fish and Game will now need to certify this non-payment to DMV, which is a higher bar than simple notification, and adds requirements for Fish and Game to notify a person of the consequences for failure to pay, as well as adds a process for appealing the non-payment certification. The intent of the bill is to incentivize those folks who are found liable for search and rescue costs to pay those costs. DMV has been consulting these changes and are in agreement with them, and we do have Colonel Jordan here to answer questions as well. But I just wanted to say a couple of additional things. The issue of search and rescue costs has been with us for quite some time. I remember having to, starting to try to deal with this when I was serving on Fish and Game in the House 14 years ago now. And what has exacerbated this, as you know, Fish and Game is a self-funded department, and the cost of these search and rescues in some cases can be extraordinary. And we are asking Fish and Game conservation officers and others to essentially risk their lives in very difficult circumstances, sometimes requiring helicopter support to attempt to rescue these folks. Now, one thing that we did a few years ago was to pass the Hike Safe program, so that if you pay your $25, you get your Hike Safe card, then your, shall I say, not your stupidity, but perhaps your irresponsibleness can be covered, and there's an awful lot of education of the 10 essential pieces of gear that people should have when they go out under any conditions into our mountains. But nonetheless, there are difficulties of people who get in these circumstances, and that cost is then borne by the department. We finally did put some general funds into Fish and Game, in part to recognize the way that rescue costs were cannibalizing the Fish and Game budget. But it's clear that that they are now requesting another tool to put into operation the authority they have had to notify and request DMV. I will say that you're probably going to hear some anxieties in general about suspending people's driver's license because that is their livelihood. If you take somebody's license away, they can't get to work to get the money to pay the fines. And I know that, you know, in other cases we've had in transportation about this issue, that we want to be very careful that every effort has been made to not get to this point. But you know, it is complicated by that. I think the need of the department to do something about search and rescue costs has been demonstrated. We're trying to address it. This is one more way to do it. So I'd be glad to answer any questions, but you're going to get the correct answers from Colonel Jordan.
Well, I do have are those who get that hiking, are they exempt?
They're covered.
They're
It's
completely
like a
covered.
little insurance policy.
And the second one I have is, what about the out-of-staters?
They can buy the car too.
But how do you attach their license?
Oh, excuse me. We have reciprocity agreements with states, so that if a license is suspended in one state, the others, if we want a suspension, we can request it.
And my final is, how do we promulgate this so that people really understand when they enter into the woods, enter at your own risk? I'll ask Senator Kevin, Colonel. Thank you. Questions from the committee?
Thank you, Senator, for taking my question. It may be Fish and Game that needs to answer this, but do we know how many people are in arrears on this?
I think they'll give us a sense of the number and amounts of money too.
Thanks.
Thank you.
And with that,
Thank you very much, and good morning. So Senator Waters did a great job kind of recapping all of that, so thank you, Senator. And he is correct. We made runs I did for 20 years trying to get search and rescue adequately funded, and a couple of great things fell out of that. One was a Hike Safe card, which still generates in excess of $200,000 for that account, which is very helpful. The second thing that was not really as helpful, although I'll say that, and then I'm going to tell you how I think it has helped. But the legislature, in some of our discussions and debates, said, well, what are we doing about these people that are reckless, these people that go up? So these are people that leave at 3 o'clock in the afternoon to go on an 8-hour hike, people that are told the weather is going to be very bad and you're not prepared, and they ignore that advice and go anyway. People on alcohol, people on drugs, which, by the way, is growing. Our response to that, we're changing some policies because it's growing so fast. So the question to me was, how do you address that? And I literally said to the legislature, I don't have any authority to address that. So this was born in 2008. June of 2008, it came into effect where the legislature gave us the authority to bill search and rescue when we, along with the Attorney General's office, deem that it is in fact reckless or negligent. And in that initial proposal, or that initial law, 206-26BB, a paragraph was put in there that we could then, if in our efforts to collect this money, if we were unsuccessful, that we could then suspend their licenses. So we do 200 missions a year, roughly. It varies from year to year. On average, I'm billing 10 to 12 people. So we don't do it often. We don't do it often for a number of reasons. I don't bill anyone in a fatal. I don't bill anyone who has a Hike Safe card, in-state or out-of-state, anyone who has registered an OHRV, a boat, have a hunting license or fishing license. All of those folks have contributed to the system. It's just people that are outdoors type people that have not possessed one of those cards or one of those things. And then the fact we have to find, in fact, that they were negligent. And the way that's done is the on-scene lieutenant who runs that mission makes a determination based on interviews and inventory of the equipment. He relays his decision in a written form to me with a report where we review it. My command staff reviews it. If we concur that it was negligence, we send it over to the Attorney General's office. They must concur that it was negligence. So it's done very carefully. At the end of that, we send them a bill, and we basically we then become a collection agency. I have a young lady over there that is on the phone all the time, setting people up with promissory notes. We make payments because some of these rescues are run into a good deal of money. So we work at great lengths. I personally take a lot of these calls for people that don't have the ability to pay it. I take that in. I raised 3 children. I know what that means, and so we take that into account. When you get a bill for $60,000, it's not reasonable to think that someone's going to be able to pay that in 30 days. So we make special decisions, basically. I've accepted half the money. The Attorney General has allowed me or given me the latitude to negotiate with these folks. So when we end up with someone who we are looking to suspend, it is someone that we either have heard absolutely nothing from, it is someone that has signed up and agreed to make small monthly payments and has not made one. It's the extreme. So we're talking about 3 or 4 people per year, if that. And so I was forwarding those over to the former director of motor vehicle, and I apologize, I never could say her name when she was the director. I'm not going to try now. She called me one day personally and said, you know, I'm not comfortable with this because the law isn't really clear. We didn't get it right when we put it in law, and I kind of agreed with that. She reached out to her Attorney General representative for Department of Motor Vehicles. I reached out to mine, Chris Haslam. They worked together to come up with a language that's before you today, and it took them last year to do that. They got it to me this year, so I asked Senator Waters, we asked Senator Waters to bring that before you. So it isn't done often. In answer to your question, Senator Avard, we suspend the rights of the person, so they can still operate in Mass or Rhode Island, but when they come back to New Hampshire, they would not be allowed to operate. While I understand some of the pushback that people have on that, I will tell you this. In court fines and default situations, you will not collect that without doing a consequence like this. The only time I see these folks is when they go to renew their license and they find out they got to pay the bill to do it. And then I'm amazed at how easily they come in and do that. It's a little frustrating because if we could have done that before, we wouldn't have had to gone through this process because it costs the state money to do it too. So I would encourage you to do it because there are a handful of people and these are the worst of I don't know how else to say it. They're the worst of the people that we deal with because we don't do it unless we hear nothing from them and they have no intention of paying it. Mm-hmm. We have court action, they can appeal, and they will be able to appeal that suspension. That's all built into that language. So it doesn't take away any of their rights. It gives them the right to argue it. So I thank you for your consideration.
Thank you for your testimony. Questions from the committee? Senator Bertzel?
Thank you for taking my question.
No problem.
How much are we talking, how many people are in arrears right now, and how much approximately are we talking?
So I didn't add up all the ones that I have because we stopped sending them over there 2 years ago. So I have less than 20 waiting to be suspended, I would say, at this point. And total money, we're probably in the range of $80,000, I would think, because they're all fairly small. They're all $1,500 or less, and they're ones that we've heard nothing from.
Thank you. And how many are out-of-staters? Do we know?
I didn't look at that, but I will tell you on our rescues, I look at that closely because people ask that all the time, and surprisingly, the rescue missions are split right down the middle. So this isn't a Massachusetts thing. We have our own residents right here that make poor decisions. So it's split. It's split. Actually, it's interesting. It's split down the middle pretty much for in-state and out-of-state. It's also split pretty much down the middle for male and female, which is another question I get asked a lot. So it's there's no way to stereotype them, I guess. And we've had some sad ones this year, as you know, really tragic, avoidable incidents. I'm very frustrated by it. Yes, sir.
How does this affect the retroactive delinquencies?
So we'd have to look back. I think I would take a look back at how far back we want to go. It's been about 4 years, I think, total now. That would be the furthest back that we would go. I'm a little more concerned about the recent ones, to be honest with you. I think after 4 years, my hopes of collecting some of those are probably gone. But some of the more recent ones, we might have a shot at that. I don't see us doing it a lot. Hike safeguard? I do. So you folks gave that to us last year, I think, the ability to do that. I'm a little hesitant to do it, and I'll tell you why. People are buying it pretty readily because I think it's affordable to folks, and we're selling a lot of them. Every year since 2015, it has increased. I've not seen it not increase, so I'm very hopeful on that. If you notice, any and all of our press releases and a lot of our live interviews, we mention it because we want people to understand it, that it's a good thing to buy into, helps prevent this stuff. So we can increase that. We're a little bit hesitant to do it because it's working very well, and I don't want to do anything to mess that up, quite honestly.
How does this treat minors, kids under 18?
So that's a good question. So minors under 18 would come under the family card. I would never bill a minor under the age of 18. I would be hesitant, quite frankly, to bill a parent of a minor under the age of 18 unless I could make the nexus that the parent should have known better, basically. We get some pretty wild calls relating to minors. It's disturbing to me that parents will let a minor come up and hike a 4,000 footer by, a couple of minors, but they do it. I'm really hesitant to do anything with that.
And the average cost of a rescue?
So that's the $30 million question. That's almost impossible to determine because they run anywhere from, depending on who responds and what we use for resources, they can run $500, $550 to $60,000. So I've tried many times to average that out, and it skews because all it takes is a little Emily Sotelo that went on for 4 days with 4 days of helicopter flights, and I'm in excess of $100,000 on that one search. So it's hard. It kind of throws off that average. But I would say, I've always said $1,500 to $3,000 is about average for rescues. That
All right.
range.
Dumb question because I do hike.
None are dumb.
Mount Monadnock. We're
Yes.
going up the cross trail, and on the way down, somebody trips and hurts their legs.
Yep.
Could that be a $1,500?
No. Well, it would cost us that, but I wouldn't bill for that. So we never bill for an injury.
Okay.
If a good hiker or any hiker falls and sprains their ankle, that's not something that's their responsibility. If they go up without proper equipment, no pack, no water, no ability for any of that except their cell phones, that's something that they will be billed. And we have that. The old adage was, I get calls from many other states because everybody's looking at this. Everybody's in the same boat. And so they'll say to me, how's this working? And the one thing I can't measure is I got to believe that the fact that we can do this prevents some of it. I think people take pause and think about it maybe and don't do it. That's number one. I don't have a way to measure that, but I think that happens. And the other thing that I heard a lot in this body when we were trying to start this was, well, people aren't going to call you. They're going to let it go because it's going to be so much money, and they're not going to call because they don't want to pay. I don't find that at all. When people need an ambulance, they call an ambulance. The last thing on their mind is how much is this going to cost. Now, when I get them in a litter and we start down, get them stabilized, we have that discussion. Am I going to be billed for this? Should I expect a bill for this? And I've educated the officers on their commenting on that because they don't make that decision. So, but I don't recall billing a fatality or an injury since I've been the colonel, and I would hope that would continue.
Would you believe I've seen people hiking with flip-flops and barefoot?
Yes. I'll tell you a very sad story, and I have her mom's permission. Emily Sotelo was found barefoot.
Oh.
And what I was just telling someone here today, what happens is they have insufficient footwear. Their feet freeze very quickly. They don't feel those shoes come off, and they come off, and it's quite common to find them barefoot. It's really sad to find a 28-year-old girl in itself, but to find a 28-year-old girl who's barefoot in 30 below weather is tragic, absolutely tragic.
Thank you very much for your time.
Thank you very much for
Any
your
further
help.
questions from the committee? Seeing none.
Senator Pearl's good to see you.
And okay, so Lily? And you're with the ACLU? Welcome.
Thank you. Good morning, Senators. I'm submitting this testimony on behalf of the American Civil Liberties Union, as mentioned. And I appreciate the opportunity to testify in opposition of SB 13, which amends the procedure for suspension of revocation of a driver's license for non-payment of a search and rescue recovery expenses. This bill would support a policy that is ineffective and harmful to Granite Staters. While this bill may only affect a small number of people in New Hampshire, the practice and policy of suspending driver's license for non-payment of fines and fees is ineffective as an enforcement mechanism for collection. This system of revenue generation will lead to needlessly pushing people into the criminal legal system. Driver's license suspensions have no financial justification. These suspensions do not improve the outcome of debt collection, and in fact, there is growing evidence that eliminating driver's license suspensions for non-payment can save jurisdictions money and maintain or even increase compliance rates. While proponents of license suspension argue that they are necessary as an enforcement mechanism to ensure payment, research shows that this is not true. In cities where debt collection suspension was reformed, there has been no negative impact on the collection of fines. And a driver's license is crucial for people who live in rural areas and especially in parts of New Hampshire. New Hampshire's public transportation is unreliable and underfunded, with only 34 of New Hampshire's 259 towns having access to a fixed route transportation system. A valid driver's license is vital for accessing basics like employment, doctor's offices, and bank accounts. The importance of a valid driver's license is greater in New Hampshire because the state and its majority of its localities lack basic public transportation infrastructure. Thus, wealth-based driver's license suspensions force poor people into an impossible position to choose to drive illegally and risk incarceration and even more fines in order to get to work or meet personal family needs, or choose not to drive and lose needed income and access to education and other services. In addition, having a valid driver's license is a requirement for many jobs, including construction, delivery, and trucking. And many employers consider a valid driver's license as an indicator of reliability and employability. Ending the practice of driver's license suspension for unpaid debt will enable poor Granite Staters to better support their families without harming public safety. Debt-based driver's license suspensions unnecessarily ensnares people into the criminal system. In sum, suspending driver's license for non-payment has no financial justification and could ultimately lead to a loss in the workforce, ensnares people in the justice system, and lacks any public safety justification. For these reasons, I respectfully urge this committee to oppose SB 13, which would make it more difficult for Granite Staters to access employment, medical resources, education, and so much more.
Well done, thank you. Questions from the committee? I have one question. If not, how do you have any suggestions on how they could recover their funds, if not by doing this bill? Meaning, how would they enforce the law?
That's a great question. I think it's tough. This policy is ineffective. It's proven not to be successful at regaining the funds lost. I think it comes down to education of the dangers of wildlife and making sure folks know that the risks that they're taking on, and in terms of getting the money back from those search and rescue losses, driver's license suspension is not the answer.
Thank you very much for your testimony. Any further questions? Seeing none? I don't have anybody else to speak on this. As any latecomers, are any latecomers here? All right.
Can I ask another question of Colonel Jordan? Mr.
Certainly. Colonel?
Thank you, Colonel Jordan. So you said the department ends up acting as a collection agency.
Yes.
Do you think that the yield of collections would be increased if you put it out to a private agency?
We discussed that. I worry about the expenses incurred from doing that. So this billing procedure ends up in a lot of this costing us more money than we're collecting. I do think it's an important tool. I'm not ready to give it up. I think it's an important tool to prevent rescues. I think it prevents some, so I'm not ready to give that up. But I think we'd have more effective collections probably, but I don't know what the cost of that would be. This doesn't make us a lot of money, quite honestly. It doesn't recover, because I'm doing 200 and I bill less than 10 or 12. And the suspended licenses are less in every year would be less than probably 5. So it's not huge. I would respectfully, very respectfully disagree that it's not effective. It is the only tool that brings them in. It brings people to the table, and the court systems, I think, will tell you the same. I'm all about it. You're suspending a freedom, but I also have to look at it when I write the check. I got to have money in the checkbook to do that, and that's the problem. And it was something that the legislature gave me. It's not something that I asked for. The language just isn't clear to do it now, and this clears that up, basically. I would prefer any other method, quite frankly, but I have this, so I'm trying to make the best of it.
Thank you.
Thank you.
And if I may,
Yes.
so it's not as though they have to pay their bill all at once, so you get them on. a
Oh,
plan?
absolutely not. If they, I've sent many letters and made calls that said, listen, this is your last call. I've sent you 3 letters. I got to do something. So call me and let's make arrangements. You don't have to do it that often. It's for the people that completely ignore you and have no intentions of paying you.
Thank you. Senator Bertzel?
One last question.
Yes,
for me.
ma'am.
If someone their license is suspended and they negotiate with you, and they start paying, is that license taken off?
Yes, that's what I've done in the past. Is if the payments start, even if it's a minimal monthly payment, they're trying to make those payments. I want them to stay working because that's how I'm going to get my payment. So yes, we do that. Thank you.
Senator Pearl, do you have a question?
No, I think it's been answered, actually.
Okay, thank you.
Thank you.
Thank you very much. We're going to close the hearing on. And you are recognized.
Thank you, Mr. Chairman, members of the committee. Senator David Waters, District 4, introducing Senate Bill 14 relatively to the use of game cameras. I'm introducing this bill also at the request of the Fish and Game Commission to provide guidance and clarification around the use of game cameras for hunting. SB 14 borrows liberally from the House-passed version of HB 490 from last session, which most of us will remember well, which dealt with the same topic but then died during the committee conference process. So what the bill does, it adds the definition for game camera. It establishes a 24-hour time frame between viewing wildlife and then taking that animal. Requires annual written or posted permission of the landowner. Require cameras to be labeled with name and contact info of their owner, which is one of the things that I think we all agreed on pretty easily. Provide that only law or conservation officers may seize unauthorized cameras. Allow exceptions for use of these cameras under scientific permits, warrants, or by Fish and Game staff. And then establishes a penalty not to exceed $1,000 per violation. As I think we have all heard, use of game cameras is a major concern to landowners, and Fish and Game receives frequent complaints from landowners about their use. The intent of SB 14 is to allow for their use in a manner that will satisfy all. We'll see. You know, we will hear there is some support from various groups here, and Colonel Jordan is here as well. I'd like to mention a couple of things. As I said, you know, we went through this last year, but this really is it's an interesting kind of perennial issue, is how do we negotiate constitutional rights, you know, the right to hunt and have access to land to hunt, and also the rights of private property owners. And I will tell you, you go back about as far in common law as you can, and you see this kind of negotiation. I won't call it a conflict, because I think it's just, you know, we often have in a democracy various rights that have to be negotiated out. And, you know, frankly, it goes right back to Robin Hood, too, you know, whether or not the forest could be closed to hunting. And so it's an interesting history and an interesting conflict. And we have heard very strongly from hunters and the use of these cameras and the right to hunt. And then also we have concerns about privacy for landowners, and you know, certainly we don't want the result to be that more and more landowners start posting their land, because that just defeats purposes here. I would like to point to a possible amendment, which is 0003S. Oh, I didn't get 001. Okay, I was close on the amendment process. That was the first amendment OLS had to do from an undecided senator. Anyways, and I want to thank Senator Pearl and Chairman Spillane for providing some insight here, particularly as to what might have more success over in the House. So if you'll see here, what this does would change the bill to say that the game camera has to go underneath the provisions that I've outlined if it's within 300 feet of a domicile without the written consent of the property owner. And then it gives a written permission expiration date of the end of the year, which is, you know, a few weeks after hunting season ends, unless revoked or extended by the property owner or his or her designee. And then lastly, the $1,000 just really seems a bit over the top for this offense. So this is why $100 is the figure there, and subsequent conviction another $100, but also potentially forfeiting the game camera and related fascinating devices used during the violation of this section. So, you know, the committee will hear more testimony and decide if it wants to go in this direction of the amendment. But I'd be glad to take some questions. But I think mostly Colonel Jordan will be providing some perspectives from Fish and Game Commission.
Okay, thank you very much, Senator.
All right, thank you.
Before I ask Colonel Jordan, I recognize Representative Goley. I know you don't want to speak, but did you see the amendment? I have. Nod, yes, no? On the amendment? Okay. Thank you for your testimony. I recognize Colonel Jordan.
Thank you, and again, good morning. So, you know, I guess I want to start by saying that this is no way an anti-hunt bill, because quite frankly, I think you'd be hard pressed to find anyone in these two bodies that hunts more than I do. So I am absolutely a pro-hunter. My issue is, and I think this is very important for you to understand, it is the #1 complaint that I get from landowners, and it starts in September and it goes through till the end of December. People are appalled that these things can be allowed on their properties without asking permission. And I've told them, I've changed this to, well, we're you know, last year we tried to build, this year we're gonna try to rewrite it. I understand it, I get it. I personally would wanna know who's got them on my property. It's also, I think part of the problem is these cameras have been reduced in cost and a lot of people are using them. I've got people posting cameras on top of cameras to find out who's hunting in their specific area. And we're all talking about land that none of these people own. And so it ends up irritating a landowner. You know, I've got a property that I hunt on. He's very gracious. He allows us to use it. It's unposted. He's getting a tax break, admittedly, for that, but it's not huge. And I think he's putting up with a lot of nonsense to get that. They're parking in his barways. They're putting up tree stands. You know, I met him the other morning on this piece of property when I was out walking. And he told me where 3 stands were, you know, that he had no knowledge about. And he's okay with the stands, but it's the cameras that make him mad because he just doesn't understand where those pictures are going. So some of the pushback that I get from the sportsmen is it's difficult to find the landowner. I would disagree with that. I think it's easier today than it's ever been. I have an app on my phone that will tell me, it's Onyx, I use all the time. It's actually such a good app. I bought a subscription for every one of my officers, and it gives you the boundary lines. It's incredibly accurate, and it'll tell you who the landowner is. We use it all the time. So that is not a challenge. We do it for baiting, we do it for trapping, we do it if we put up a permanent tree stand. So the idea that it's hard to find the landowner, there are probably occasions where it may be, but I don't think it's impossible. We find them to bill them for taxes. We certainly can find them for this. There are landowners out there that don't care. There aren't many of those that I've heard from, but I'm sure there are some who don't care. I'm more concerned about the ones who do. And my other concern is this. In the southeastern corner of the state, down where Senator Waters is, we have a very healthy deer population. We have a lot of problems with deer down there. We have a lot of problems. We're starting to have problems with bear. So we give out extra permits, we're giving out doe tags and all these incentives to get hunters to go down there. And I keep telling my wildlife division, this has very little to do with resource. It's more about access. They can't get there. The land is locked up. And that if we're not paying attention to that, we're not paying attention. That is slowly moving across the state. Monday afternoon, I'm on a dead end road. I never saw a posted sign in the town of Tilton and Northfield. I start running into brand new posted signs as I get near the end of the road. This is a farmhouse with a woman that runs it. She lost her husband. So it bothered me. They were new signs that were obviously put up this year. I drive to the end of the road and she's out on the porch getting ready to walk her dog. So I pull right in because I can't keep my mouth shut, and I want to know why she did that. And so I went in, I had a nice conversation with her. I said, I got to ask you, these are brand new signs. I said, and you had a lot of land here. She said, that's right, 555 acres. And I said, I got to ask you, did you have a problem? She said, I certainly did. She said, this was one hunter who parked near her paddock every day. He just wouldn't go down the road out of sight. He went in every morning with a headlamp on to his stand carrying a rifle, and she didn't like that. So she waited for him one night and said, hey, could you just go down the road and hunt and stay away from my immediate residence? And he gave her a bunch of lip that it was his right, which I'm not sure where that's written. I've never seen a right to hunt. It's not a right, folks. It's a privilege. We are hunting on land because people sitting behind me are allowing us to do that. And I think if we don't start recognizing what their concerns are, that's going to change. And I don't want to see that as a hunter. I want to be able to go hunt on these properties. So she posted 555 acres to the world because one hunter upset her, and I was unable at that time to convince her to change. I'm going to keep going back. But that's the exact thing I'm concerned about. I'm also concerned, and I appreciate the efforts in the amendments. I know what we're trying to accomplish here to get it through the House. I get it. I've had those same, probably similar conversations as you have. But I don't think privacy stops at 300 feet. I just don't. To be quite honest with you, I don't own a lot of land, but I'm very proud of what I do own, and and it's open, and it will always be open, I promise you. But if I find a camera out there, it's going to come down. If they didn't come bang on my door, I want to know who's taking those pictures and where those pictures are going. And I think every citizen in the state of New Hampshire should have that right. If I went out as a police officer and posted a camera on private property, the AG would have me in his office, as he should. I think everybody should be held to that standard. I think we should recognize that property owners have a right to ask for this. I don't believe that you're going to find a ton of them that are going to say no to you. They just want to know who you are. They want to know who's taking those pictures, especially certain farmers. This is a bill that the Farm Bureau, which is a lot of members, the Timberlands Association, which is usually pretty respectful and quiet. Both these groups are. They very seldom get cranked up over something. In my experience of doing this for 30 years, they are in the Wildlife Federation. They are all over this because they recognize that we got to do something with this, I think. And this 300-foot stopping, I appreciate what you're trying to do. I just don't think it's the answer. The landowners, to me, aren't complaining about it's 500 feet from my home. They're saying, I don't want it on my land. My land at the very last foot of my property is just as important to me as my front lawn is, folks. I got to tell you. And you're not going to do anything on my front lawn that I'm not going to allow you to do back there. It's equal to me. I'm paying the taxes on it. Damn it. I respect that.
So that 300 feet basically kills the spirit of the bill.
It really does. It really does. I want something, because I'm going to tell you something. The hardest time I had in this job was last year when I went back to these groups and said we didn't get 490 through. People were angry. I asked them to wait until this session to try, and I tried to rewrite this bill again. I took a lot of what was in there last year and I put it in this one. I split the tree stand off it because I didn't want anything to interfere with it. And I'm really putting forth an effort because I know if you could get the calls that I get, you would understand it. I get the hunters. I want to go out and put a tree stand up on a piece of property and not be bothered. Quite frankly, the job I do, I don't want a lot of people to know I'm out there. But I just can't bring myself to do that because I'd be very angry if someone did it on my land. So I go bang on the door. You know, this old buck, I brought him a turkey the other day because he's let me hunt on his land for 2 years now. And he's paying taxes on that. You know, he could very easily post that and keep me out of there. He doesn't do that. In fact, he allows me to park in his yard. He offers to let me park in his yard. It's not a big deal to bang on the door and give the landowner that kind of respect, I don't think.
So as I'm driving down the highway a few years back, I'm seeing 300 squirrels on the side of the highway.
We tried to fix that, Senator.
Yeah. So What does that have to do with this bill? It has everything to do with this bill, because now I'm seeing deer on the side of the highway,
Right.
like the squirrel.
Yeah.
And if people start posting their properties, that's going to exacerbate that. It's not just about the game in the hunting, but I'm seeing deer, exit 7. I just missed one the other night,
Oh,
my
yeah.
buddy hit it. And
These mild winters, I have 9 on my lawn regularly, and I won't shoot a deer on my property because if they, quite frankly, if they can't come to my house, where can they go? So I drive away, Senator Pearl knows this, I drive away, I hunt on someone else's land, and my wife texts me the pictures of a doe standing at my front door. So we do have a healthy deer herd, and these winters are gonna increase that. These mild winters are gonna increase. That's a good thing. I think everybody enjoys deer, and certainly the hunters are benefiting from that. We had a record year. We're not gonna have a record year if landowners post their property, folks. And the issue is going to be, the hunters will tell you, well, then landowners are gonna have to deal with the problems. Yeah, they are, and they're gonna kill deer, and they're gonna be wasted. And that's really not a good resolve.
And that's kind of where I was going, because this was a wasted deer, and it was just left on the side of the highway,
Right.
2 miles before me.
The most important thing that I want to leave you with is this. The landowners that I've talked to, and there are a few right behind me, they are not anti-hunters.
Right.
They don't mind us hunting. They're just asking for the simple respect of letting them know that you're putting this stuff on their property. I don't think that's unreasonable, quite frankly. I think that's a reasonable request. I think anyone, if you had an acre of property and you're sitting in your living room and you watch somebody come on your front lawn and put a tree stand and a camera up in that tree, I will promise you, you are going to call the police. Why wouldn't you? These guys should have that same ability. Whether it's 300 feet or 3,000 feet, that's their land, and they should have that same ability. That's the one thing I want to leave you with.
Thank you, Colonel. Questions from the committee?
Well, thank you, Colonel. I appreciate you coming in today.
Thank you.
And I just want to know if I could get written permission to hunt in your yard. It
You-
sounds like you have better
you
gear
can.
than I do. No, in all seriousness. So I had worked with Senator Waters, and I've talked with some members on the House Fish and Game, and the thought behind the 300-foot, it was consistent with the discharge of a firearm in hunting, and it was
Right.
just a common number that
Sure.
that hunters were familiar with. We were trying to find a middle ground where, because this is really causing many hunters to bristle about the thought of having to do this, and I'm an avid hunter myself. I'm also a large landowner, and I understand both sides of this issue.
Sure.
It's been one that's sort of been near and dear to me on both sides, and just trying to find a center ground with that. But I think, to me, it seemed like the most important part of the bill was at least getting the names of the folks who were placing these cameras on the property, and I think that's of real importance to the landowner.
Yes, I would agree.
To at least know that. And the sticking point seemed to be the written permission portion for, what the hunters consider to be backland. And I agree with you. The landowners, they have a right to their land, and they own
Right.
it. And, I have a few hundred acres that I own myself.
Sure.
I always appreciate knowing who's there. But to me, this, at least getting something through was the goal, and I was hopeful that maybe if we took a bite at this at first to at least get the names out there, and so that people could see, landowners can understand who was on their property, and you'll see a similar amendment on the tree stand bill, which is next.
Right.
We've kind of talked about the two together here.
Sure.
And would you feel that at least getting this portion through and eliminating it so that we were dealing with the privacy concerns related, especially around their domicile, their buildings, and their family? Nobody wants pictures of their kids playing on the swing set
Right.
being transmitted to someone they don't know where they are. I mean, that camera wouldn't last long on my property
Sure.
either if I saw that.
Sure.
But I'm a little more tolerant of something that's 3,000 feet behind my house and it's filming a back section of woods near a swamp. I'm a little more tolerant of that.
Yeah.
But I, again, would like to know who's there, and that's
Yeah, understood.
still included in the bill about having that identification on the cameras. I guess the question is, are we willing to accept that we can get something through, or do we want to try and go for the ball of wax? I mean, that was the whole idea behind the amendment.
I think so, and I appreciate the effort, and I know that's been the effort. I understand. Everybody's been upfront with. I've had many conversations about this. Neither one of these were surprises to me today, and I agree with you. I think I got to tell you, we better make steps in some direction here. I've not had a landowner in those calls actually mention a name on a camera. I've had them say, how do I know who it is? And I said, well, that's a $30 million question because I have a bunch of cameras in my evidence room. I have no idea. I put a card up and nobody ever calls me. You know, it gives you kind of a stigma. But they think that they're in trouble. And really, all I want to do is give them back their camera. I could put Bass Pro out of business with the cameras that I have. And it's ridiculous. I don't want to do that. So the name is going to be a help. Anything that we can do is going to be a help. But I just want to make sure you understand the landowners are hard pressed on, I want to know who it is. They are just, and I don't feel right not bringing that forward to try and change it. That's the majority of the calls that I'm getting is, I want to know who it is. It's interesting. It's not, I don't want them on there as much as it is, I want to know who it is. I get a few that say I don't want them on there, but most of them are, I want to know who it is before they put them out there. And I understand that.
So would having the identification on the cameras
Will
at least
help.
give the landowner an opportunity to know who it is? Now, again, I understand the written permission part. You'd like to know beforehand and ask
Right.
permission. And there's a big part of me that doesn't think that's unreasonable.
Right.
Being a landowner myself.
Sure.
But I do understand, I guess, in some instances, it may be a bit of an imposition for the hunter.
Right.
But I agree with you. The landowner has a right, the hunter has a privilege. And we need to make sure that we understand that.
That's correct.
And get that in the right.
Yeah, I think that's a help. Having the name on it will help. I'm hesitant to make the landowner make it his responsibility to patrol his property to make sure that this is followed, I guess. And I think if we just require, the identification marks on both of these bills are going to be helpful. I'm a little worried about telling a landowner, and the only way that we're going to enforce that is you're going to have to go out and find them and let me know who it is. I think it should go to the hunter who's there enjoying it. I ask permission for everything, so I don't look at it as a huge challenge. I know there are people who don't do that, and I think it's a bigger challenge than what I found it to be. It's not hard to do. And I've had people say, no, I have strong feelings about hunting, and I'm okay with that. I'd rather find out that way than have one of my guys come chase me out of a tree.
Sure.
Say you're on land that they don't want you on. I'd rather do that ahead of time. But I'll take, at this point, any progress we can make on this, I think would be good. I'd rather have a landowner, who I'm sure you're going to hear from, testify to how important each element is. But the calls I get are more of, I want to know who these people are.
Thank you.
Thank you.
Senator Waters?
Thank you, Mr. Chairman. Thank you, Colonel. So just a minor question is on the change of the fine to $100.
Oh, yes, I'm glad you said that. I wanted to address that. So we put in the original bill up to $1,000 because that's what the law is now in violations. You could charge up to $1,000. So understand, some fines, they leave it open at the discretion of the prosecuting officer, and we go in and ask for $100, $180, to stay in line with that. I don't have a problem if you want to legislate basically what that fine would be. I don't see any issue with that. I don't know that $100 is a huge deterrent. We may want to consider something a little stiffer than that, but I don't have any issue with $1,000. We use the language up to $1,000 because that's the way the law reads for violation level offenses. It also reads in misdemeanors that you go to jail, and we've never put anybody in jail, or very seldom put people in jail.
Further questions?
If I just may follow up, I've puzzled last year and puzzled this year about whether or not there any way to thread the needle here.
Yeah.
And
Yes.
do you think that, a lot of the language of this bill is, saying that you got to get permission on everything, and the amendment says just permission up to 300 feet.
Right.
Were we to say that beyond the 300 feet that, and there's going to be a name on it, that the landowner would have a right to ask for any camera to be removed?
Oh, he has that right now.
So-
So understand a landowner, and they do it. They come up, they'll call us and say, I've got cameras on my land, I want you to remove them. And we come out and remove them. So, yeah, they have that right now. My issue is then we're making the landowner do the work, basically, which I think is a mistake. I think it should be on us as hunters. We're on their land. They're providing the access for us. This is just a personal thing. I don't think it's fair to ask a landowner to patrol his own property to keep this at a minimum. I think it's our responsibility to make sure that he doesn't have to do that. The other issue that I have before other testimony comes, there are landowners who want the ability to seize those cameras on their own. I will tell you that is not a good practice for a number of reasons. I've got a couple of issues I'm dealing with currently where people went out. Most of these cameras are expensive and stands too, and people lock them down. And in order to remove them, you got to destroy property to remove them. And it's a really hard sell for me to go back to a landowner who sees the camera, cut the cable, and I say to the landowner, I got to return the property to the guy who owns the camera. I return the property, and the property owner says, "What about my cable? What about my lock?" And I got to go back to the landowner, and he's civilly liable for the damages for the property because he destroyed it in removing that camera. That's the way our law is currently. So that's kind of yeah, my God, I know. And so I don't want to make that call, and yet I have to because they're liable for it. And the other problem with having people do that is they're caught on these 24-hour cameras, the instant. So the camera owner is seeing the landowner take his camera down, and that ends up in a confrontation. So I can't stress to you enough, if we're going to seize equipment, and I would like to keep that at a minimum, but if we're going to seize equipment, make sure that you have a uniformed officer doing that, because I think you could exempt a lot of those problems by doing that. And I don't care if we allow a landowner to put a piece of tape over the lens until an officer gets there, but allowing him to remove it can get us into, it has gotten us into all kinds of trouble. So just caution you on
Senator
that.
Bertha?
Thank you. I'm obviously new with this committee, so I just want some clarification.
Yes, ma'am.
And I believe in hunting, but are you saying that these hunters are going on to property that they don't have permission to do hunting, and they don't have permission to put the stands up, and they don't have permission from the landowner to put these cameras up? And go ahead.
Yes. So yes, but understand a couple things. So yes, these people are going on property that is not posted against trespassing or hunting, and they can deploy cameras, they can put up tree stands, and they can enjoy the afternoon hunting on it. The law doesn't require them to get permission. We recommend it. We've always recommended it as an agency for better landowner relations because we recognize how important the landowners are in all of this. Because if they, what I worry about is some of the states that not far away where you cannot hunt on, there is no open land. It's all posted. And people have to get permission every time you want to leave your vehicle. New Hampshire isn't like that. And I worry because we have some hunters that think they have a right to that. They don't have a right to it. It's just there's no law to prevent it. It's not a right. It's a privilege to hunt. And it's a privilege to go on someone's open land. So that your point is exactly why I'm here before you today. I think we ask a lot of our landowners. I personally think we ask a lot of them to keep their land open so that we can have access to it to enjoy it. And so when they come to me and they say, listen, I've had enough of this. You need to address this. I take that pretty seriously because I don't want to lose my opportunity, and I don't want anybody else in the House or the Senate to lose their opportunity to go on that open land to hunt. And I truly believe we are going to lose property if we don't do something with this, because there are some angry landowners that have had enough of it. It really is an invasion of privacy. If you look at it literally for what it is, it's transmitting pictures unknowingly of landowners and their property to God knows where. I think it's probably safe, but as a landowner, I don't think I'd view it that way. I don't know who that person is, and I want to know who it is. So I think any progress would be helpful, but I just urge you to think about the landowner here, because I think it's the one person where their interests are falling off here. Our hunters are important. I'm all about that. That's my job. But we aren't going to be hunting anything if we don't have a landowner.
Any further questions from the committee?
Thank you very much.
Seeing none, thank you very much.
Thanks for your help.
I have Yeti and Sasquatch in favor of the bill, opposed to the amendment. Okay, that was supposed to be funny. It's the timing thing, I guess.
Squirrel camps.
It's squirrel camps. All right. I need to work on my delivery. Daniel Ducharme, in support, wishing to speak? Did I say your last name or Dockham? There you go. I can be taught. All right.
Mr. Chairman, members of the committee, I
Welcome.
appreciate a few moments here to just express myself. I am a landowner as well as a sportsman and have been all my life. I don't think this is too much to ask from our landowners. I am one who considers the ability to hunt on different as a privilege, not as a right. And I think this is the least that we can do for the people that provide this, you know, privilege for us. And other than that, I won't go into a lot of stories. As a landowner, I've had some abuse, so I understand where people are coming from. I attended a meeting with the Farm Bureau, which I'm a member of, and the Federation and the Fish and Game, and I was amazed, to be honest with you. I don't own a lot of land, it's 100 acres, but it's good deer hunting, and I have plenty of competition. But some of these people had some real, genuine problems. One that sort of caught my attention was this woman who was a farmer in the North Country, and one of her, it's a privacy issue, but if you're a farmer and you're in the lower 40, mowing hay, raking hay, baling hay, whatever, and nature calls, you're not going to run all the way back to the house or the farm to take care of this issue. So you do it in the woods, and her fear was that she didn't want to go on Facebook and see a picture of herself reliving
hay.
her in the woods. So, you know, it is a privacy thing as well. So I guess I won't get long-winded and just wanted to make a few comments, but I am 100% for the bill.
And what about the amendment, as it was discussed, the amendment of the 300-foot setback?
I don't have a problem with that, no.
Okay.
No.
Questions from the committee?
Can I-
Yes.
Mr. Chairman, and thank you for coming to testify. So the amendment says the 300 feet is the only place you need to ask the permission. You can put them on all the rest of the land without asking permission.
I'm sorry, I have a,
Yeah. The amendment says that it's only if a camera is within 300 feet that you have to ask permission. If
Oh,
it's beyond
I'm
300 feet,
sorry,
you don't
I
have to
didn't-
ask for it at all.
yeah, no, I'm sorry, I'll retract on that, yeah. Yep. Yes, thank you, I'm sorry. I have hearing aids, but right at the moment, they're not working well, the clarity part, and so I do have a little bit of an issue there.
I appreciate your testimony. Thank you very much.
All right, I appreciate the opportunity to express myself, thank you too.
Mr. Kyle Baker? Kyle Baker to the front desk, please. Thank you. How you doing?
Good morning, thank you. So my name is Kyle Baker, and I'm here on behalf of my client, the New Hampshire Wildlife Federation. New Hampshire Wildlife Federation is a conglomerate sort of association that represents hunting and fishing and trapping interests around the state. They represent approximately 50 various fishing game clubs, sportsmen's organizations, and other sort of industry groups that sort of work to advance and protect hunting, fishing, and trapping in New Hampshire, as well as access to land to hunt, fish, and trap on. We have an affiliated membership this year of about 50,000 sportsmen and women from around the state. And the New Hampshire Wildlife Federation fully supports this bill. They see it as a good balance to support the landowners that allow us to have the privilege to hunt, fish, and trap. I attended the similar meeting that Dan spoke about with the Farm Bureau, and to say the issue sort of has reached a fever pitch is definitely true. We were amazed to see and hear some of the stories that have happened and the true risk of losing access to land across New Hampshire. I can't tell you that every sportsman in New Hampshire would agree with the stance that the Federation wanted to take on this bill. But we really appreciate the ability. We've worked closely with the Timberland Owners Association, the Farm Bureau, and Fish and Game to sort of come up with a bill that we think strikes a good balance with allowing landowners to know where these cameras are. Again, we have voiced concerns in the past about confrontation and the ability to lose land simply because you're asking it. But when it came down to, ultimately the end of the vote with the board of directors to decide what position they want to take, one of the first things you learn about when you take a hunter education course is the importance of private landowners and the need for sportsmen at any age and doing anything, coming in and building relationships with the landowners and the land they want to hunt and respecting that land and the ability to use it. Because we do not have a lot of public land in New Hampshire, and it's been hundreds of years since we had open wild land to use. So without our private landowners and the other partners around the state, we wouldn't have access to hunt. We support the bill. I just saw the amendment this morning. Again, I'm going to send it back to them for some input around the 300-foot radius. My first read of it is, maybe there would be a need to expand it past the dwelling to include active areas of active agriculture, barns, farm fields, paddocks. So I think there's a huge list of areas of concerns you might hear from other landowners about areas of their property that they are sensitive to the use of cameras on, and maybe there's other conversations that need to take place. But we do support the idea of lowering the fine. $1,000 is a lot for sure, and it's higher than taking a deer out of season. That's my understanding. We would support that, and as well as clarifying that you can keep your cameras up until that permission is revoked. I saw that in the amendment as well. If that's the arrangement you've worked out with your landowner, we think that's a good step as well. So with that, happy to answer any questions you might have.
Questions from the committee? No. Seeing none. Thank you, Kyle. Appreciate it. Walt? Lacey?
Well, Lacey, yeah.
Yes, sir. All right. Welcome.
I've discovered recently I have a hearing issue in these settings, so bear with me. Tough getting old.
The alternative isn't
Exactly. That's understood. So I turn this thing on. I'm trying to figure out how to use it. I better turn it back on.
Are you listening to
go.
music while
Okay.
you're testifying?
After a couple of frustrating years complaining to various people and entities about game and tree stand issues, including a submission last April concerning pending legislation, I'm grateful now to be at ground zero in the legislative process. Thank you for the opportunity to participate. I am Walter Lacey from Keene. My wife and I own 650 acres of woodland in Keene, Swansea, and Chesterfield. I believe very strongly in traditional uses of the land, and hunting is one of them. Although I'm not a hunter myself, I am supportive of hunting on 100% of my land, and I can't foresee that changing. That being said, I have had a recurrent problem on my land with anonymous tree stands and associated game cameras. In the last few years, I've had 4 disagreeable incidents that in 3 cases resulted in damage to trees, 2 of those being valuable young oaks. In 3 instances, I attached my contact information on bright flagging tape, sometimes for months to no avail. The 4th was discovered as I prepared for logging activity 4 years ago. This past March, at personal physical risk, I took down an apparently abandoned stand and camera and delivered them to the local Fish and Game office. An illegal stand and associated camera were discovered last month on my property. An investigation is ongoing. Needless to say, I have become increasingly frustrated and peeved. I am supportive of both bills, SB 14 and SB 15, as written. They seem to be steps in the right direction. Identifying ownership and placement of this hunting equipment is mutually beneficial to hunters and landowners alike. It seems high time to have a simple, sensible solution to what should be a matter of common courtesy. You leave your gear on someone else's land, put your name on it and get permission. I view posting one's land as short-sighted, but if these issues are not resolved to landowner satisfaction, you will be forcing a landowner to take that step to reasonably control and manage his or her property. Statewide permission-only hunting may be next. Please pass these bills in their current state. My backyard should have the same protection as yours. Thank you for hearing my thoughts.
Thank you for your testimony. Question from
I
Senator
hope I
Pearl.
can hear you.
Well, first off, thank you for coming in today. We appreciate
Well,
it.
yeah, I'm pleased to be here.
And, so the amendment that we put in, or that we were talking about, would require written permission for cameras within 300 feet of your living area that you choose.
100% everywhere.
And it
everywhere.
would allow-
Again, 10 feet from my house is the same as, a couple miles
Sure.
away. It's
Understood,
the
but it
same
would
issue.
allow the cameras to be on the rest of your property with, they'd be have identifying markers as to who they were on them. And that's the question, would that be enough to satisfy you to have the ability to contact and know
I would
whose
like-
cameras
I would
there?
like them to contact me. In other
You
words,
prefer the written
I
permission?
own a lot of land,
Yeah.
and for me to have to run around and find out what's where.
Understood.
Again, a neighbor pointed out this
Yeah.
last issue to me, so it was something I was not aware of.
Understood.
So I'm frustrated in that there's I can't identify a person who attached to that, but the fact that it was even there, I didn't know about.
Okay, thank you.
Seeing none, I'm just gonna leave this on. All right. Thank you very much.
Thank you.
Mark? Ledyard? Close enough.
Very good.
Thank you.
Thank you, Chair and members of the board. I do have a letter that I would like to enter into the record. It pretty much outlines all my thoughts. I'll just try to summarize them here.
Thank you.
So my name is Mark Ledgard. I'm from Samerton, New Hampshire. I've been hunting for all my life in New Hampshire. I am a New Hampshire certified hunter safety instructor, and I have mentored many hunters throughout the years to get in board with hunting. What I've seen over the years is land being posted because of maybe the acts of a few. So our hunting heritage is really in jeopardy. And the way we protect that is by protecting the landowners and giving the landowners the ability to manage their land. So I'm here to support both Senate Bill 14 and Senate Bill 15 combined. I agree with everything Colonel said, and I do like what Mr. Dawson said. And I was going to say the same thing because my wife and I walk around my property, whether it's away from my house, away from my storage sheds, away from my trails. We are walking through the middle of the woods. I own a substantial amount of land. Sometimes we have to do our business out there. And I actually look around to make sure I don't see a camera out there. In today's world, you don't know where that image is going to end up. We just don't know. So permission, there's no safe distance. You know, we could look at I'm not an attorney, but the actual nuisance laws and invasion of privacy applies to street view. Anywhere else on the property, we should have permission from the landowner. It's a courtesy. The rights that we apply to public land really might not always apply to the private land, excuse me. So.
Questions from the committee? Well done. Thank you very much, and
Thank you,
appreciate
sir.
your brevity. J. Finney Ackworth. What did I say? Finney. Oh, that's a Z.
Thank you, Mr. Chairman. For the record, I'm Jay Finney, and I live in the town of Ackworth. And since there are some Farm Bureau members here, but most of them are down in Puerto Rico at the annual meeting, and I'm the second vice president, I will speak for the New Hampshire Farm Bureau Federation in this instance. And quite frankly, we reviewed not only the text of this bill, but we also reviewed the concept of the proposed amendment. And quite frankly, the policy committee voted unanimously to support the bill as drafted and as written. So therefore, and I'll provide some reasoning why, but I think that it's perfectly acceptable to pass this bill through unmolested, if you will. Now, on a personal level, I only own about 70 acres, which is probably a minimal amount of land, but it is in an area in Ackworth that, while it's getting more populated, is still fairly rural and fairly rural agricultural. Now, my land is pretty much a long rectangle with about a half a mile of road frontage, and were I to see this bill fail, I would probably be forced to post my land. And I'll explain that very simply from a very direct point of view, that being a long, thin rectangle, even the 300-foot rule amendment does not satisfy my concerns, where people would come up onto my house and they would then discharge a firearm or whatever. And so for that matter, I think it's just very important to keep it as drafted. I think it's a thoroughly acceptable bill. If someone wants to, and I don't post my land now, and I haven't for years, based on the simple fact that I would rather have people enjoy the land and enjoy the usage. I let one of the major trails for the snowmobiles go through a part of my land that hooks up to, I think it's called Highway 5. So on that level, I'm pleased I would ask you not to change the text. Too many societies and agencies and groups of people have worked very hard to come up with what I consider a very acceptable piece of legislation. As to changing the violation, some of you may realize that I had been the chair of the Environment and Agriculture Committee when I was in the House, and had served on the Environment and Agriculture Committee for 10 years. I believe that it's up to the discretion, and the Colonel can correct me, but it's up to the discretion from the body that would control those administrative fines to be able to fine an individual for up to $1,000. And I think that's a really reasonable and adequate deterrent. And I'm going to ask, am I correct? Yeah, okay. In other words, I realized that when we did a lot of agricultural bills, we quite frankly had to leave that open at the discretion of then Lorraine Merrill, who was the commissioner, and before that Steve Taylor, who was the commissioner. So I think I would allow that discretion, and I wouldn't change it to $100. $100 is a drop in the bucket these days.
Please forgive me for not recognizing your former state representative.
Oh, that's perfectly all right. I just wanted to address that $100 fine thing.
Well, we appreciate your testimony and your service. Any questions from the committee?
Thank you very much.
Thank you. Yep. Calling Jason Stock to the front desk, please. Jason Stock. Is this your first time?
In 2023 it is. Happy New Year.
Good answer. Happy New Year.
Well, good morning. My name is Jason Stock. I'm the Executive Director of the New Hampshire Timberland Owners Association. I have a copy of Rob Johnson's printed testimony, and then a member of our association had some email issues, Dennis McKinney with New England Forestry Consultants, and he wanted me to just belt and suspenders also provide a printed copy. Some of you may have gotten it. He said he had a couple unusual bounces. I want to thank you for the opportunity to testify on this bill. We support it in its current form. We have 1,300 members, and our members own or manage over 1 million acres in the state. And these are foresters, timberland owners, many are loggers that also own land. And they're all natural resource managers in one way, shape, or form. And they all recognize that wildlife management is part of natural resource management. And I would say most of them are hunters as well. So as Colonel Jordan said, this is not we don't look at this as anti-hunting. We look at this bill as a property rights, a privacy bill, and really a kind of a common courtesy bill. In drafting this bill, we worked with the Farm Bureau, we worked with the Fish and Game Department, and we worked with the New Hampshire Wildlife Federation, coming off of last year's failed attempts. We tried to create legislation that would satisfy our concerns and at the same time hopefully pass both chambers and be signed by the governor. This bill is not about hunting, it's about personal property and my ability to come onto your property with a device, unknowing to you, take images, some of them can be transmitted electronically onto my phone, and do whatever I want with them. And when I talk to my members about that, they're just, they can't believe that is permissible. And we look at this legislation as the law catching up with technology. As you heard earlier, as the cost of cameras has come down, so has their prevalence on the property. I get calls from landowners. I know you've received emails with respect to this bill. You've heard some stories today. This is the tip of the iceberg. People own land for a lot of different reasons. They own land for financial purposes. I may own timberland for the value of the wood or other potential values down the road. I own property for recreation. A big reason is I own property to buffer myself from my neighbors. And it's a privacy issue. If I wanted to live in an urban area, there's plenty of opportunity. Why do I live in the country? Because I like that lifestyle. I like the solitude, and I like not having to hear my neighbors or have them hear me or see me when I'm doing whatever I am at my home or on my property or on my land for that matter. I appreciate the 100-foot. I really do appreciate the 100-foot effort in trying to, as Senator Waters said, thread the needle. I appreciate that. But I want to give a couple examples of where that doesn't work. And, you know, it's one of the benefits that I have is I get invited to do woods walks with my members all the time. They'll take me out on the property, and they all have trails that are more than 300 feet. Most of them, I should say, have trails that are more than 300 feet from a home. They go out for walks. They take their grandkids out for walks. They don't want to feel like there's someone or the potential that someone is watching them. They have areas that they work. I, like one of your committee members, is a sugar maker. I have a gathering tank back in the woods that's more than 300 feet from any dwelling or structure. I don't, and I go back there, I pump the sap well, it could have been as early as last week, but I pump the sap. I don't want to have to think, is someone watching me? Am I being observed somehow? And then the last is people have special places on their property. They may have an overlook. They have an area that they go to that's just kind of quiet. Or they may have an area that they have their grandfather's ashes. I mean, these are real stories. And so the thought of having a camera there, kind of observing or watching it, and I'm not saying people are putting it up knowing that was a special place, but they just don't know. And without that conversation, they won't know. So for us, having this conversation is really important because you can say, yeah, put the camera out. I don't mind, but just if you could stay away from that back corner, that's a special place for me and my family. Again, I'll just reiterate that we see this bill as the law catching up with technology, and we think it's reasonable. We do find that the thought of someone out there observing and watching us, even if it is beyond 300 feet, we just think that there's a common courtesy here. And so with that, I'll conclude my testimony, and I'd be happy to try to answer any questions.
Jason, does this cover drones?
Drones is a whole other animal. I don't know. I don't believe it does, and I'd have to look at the definition. I think drones is a different animal altogether.
Yeah.
I think it's a whole different.
Still privacy thing. Right.
Yeah, there's. Yep.
And those pesky satellites. Just kidding. Questions from the committee? Seeing none, thank you very much, Jason.
Thank you.
Stephen Wood. Did I get somebody's name right? All right.
I did my best to spell my name right.
No, it's not the speller, it's the reader. Yeah.
I've brought you some pretty pictures, folks. Have a glance at this. Right, thanks very much for hearing me. I'm Stephen Wood. Here you go. I'm Stephen Wood. I own and manage about just shy of 1,000 acres in Lebanon and Plainfield, where we manage and own Poverty Lane orchards and Farnham Hill ciders. And our land, I'd be grateful if it's possible for the senators to see that. Okay,
Yeah,
great,
yeah,
thank you. Our land, I posted our land about 25 years ago, and you have the signs in front of you. They're about as welcoming a no trespassing sign as you could possibly have. And they've worked beautifully. And we put them up. We didn't used to post our land. But we had real abuses, like hunters in trees in view of pick your own orchards. I mean, I won't go through all the details of erosion and whatever all else, but real intrusions. This works. People, I could have brought great big stacks of hunting permissions we give out every year. We have a very good relationship with hunters and with the people who use our land. And some of them are a little, in a way, kind of excessively grateful, but they're very respectful. And I don't have to do much policing at all, and haven't had to since those welcoming signs went up. Actually, if anybody else behind me wants to see those. So this really is, as has been said, this is a private property rights issue. And, you know, there are places where the interests of the general public legitimately come up against the rights of private property owners like me. Rights of way, zoning, you know, and I approve of those things. I chair the Lebanon Class 6 Roads Committee. But hunters are not the general public. Trappers are not the general public. And I own this land. I'll save a little bit of breath. I oppose the amendment. It's not a big deal to ask permission, as has been said by a lot of people. And the people who ask permission are respectful. And it's very easy to find landowners. And if you post your land with something like that says you're welcome to come on our land, just get a hold of us if you want to play with some of your toys, like guns and motorbikes, and in this case it would be cameras. We don't have to chase people around. Hunters and walkers do it. Cross-country skiers. But they're all aware of the fact that they're on our land.
Yeah.
And I would oppose the amendment tooth and nail, because that is an abrogation of property rights in a state that has always taken private property rights very seriously. And as I say, I don't think they are absolutely, they shouldn't always reign private property rights. But in this case, the possible intrusion of a camera, you know, I'll be back up for the second bill about putting little stands up in our trees. Permission's not very hard to come by. Mm-hmm. And I think with most landowners that's true. My alternative, if too much is granted by right, and I can tell you to the next bill, I didn't even know that law was on the books, nor does any landowner I've talked to, and they were all horrified to see that to be told that it was on the books. my only alternative is a great big red commercial no trespassing sign. Now, this is not a threat. We won't do that. Or it would take a lot of abuse for us to do that. But here's an example of the relationship. This year we had wood walks cut through the forests above our main Pick Your Own orchards. And we told the hunters who came to ask permission that that section was going to be closed to hunting till Thanksgiving for the reason that people were out walking with their kids in the woods. And not that we were worried that somebody'd get shot, but it's not in some cases the best PR to have guys marching around in orange with guns with the kids walking. And we had no trouble at all. We didn't, not one hunter, nobody said, oh, that's always my favorite place to go. They just asked what date they'd be allowed to go in. I mean, I think this is just the way to preserve a respectful and workable relationship between landowners and users is to continue to acknowledge that the landowner owns the land and that the permission to use that land is the landowner's to give. And this is the reason that so many people post their land. I've argued with a lot of people who post their land saying, please don't do that. But that's why they do it. So that I urge you to pass this bill as presented and to vote for it when it gets to the floor. That's all I have. Thank you.
For your
Oh,
testimony.
thank you for your attention and for your service, all of you.
Questions from the committee? Seeing none. Well done.
Thank you.
And let's see, I think our final speaker is somebody with a big axe. Mr. Tom Thompson. Welcome, sir. Oh, we have another person? Okay. You have the
Thank
floor.
you.
Yeah.
Before I start, I do agree with the Colonel Jordan on his main issue that land is being posted at an alarming rate. And also in my statement, which I'd like to read, I do give a little bit of background and history about the importance of not only the forest land, but recreation and tourism as a whole. So my name is Tom Thompson, owner of the Thompson Family Tree Farm with my wife Sheila. We own and manage a total of 2,800 acres as a sustainable forest. 2,400 acres of that are in Orford and Wentworth, New Hampshire. I have owned forest land for over 65 years and have been an advocate for years for opening and sharing our forest land with both the state of New Hampshire as well as the general public. We have over 12 miles of roads that we allow snowmobiling clubs to use during snowmobiling season each year. We also open our land for activities for foot traffic such as hunting, fishing, hiking, photography, bird watching, annual butterfly counts, snowshoeing, cross-country skiing, along with many tours that we give. I am here today to support Senate Bill 14 relative to the use of game cameras and Senate Bill 15 relative to the use of tree stands and observation blinds as written in the bill. New Hampshire is the second most forested state in the United States. It has a total of 4.8 million acres of forest land, which is 84% of our state's land base. And of that percentage, private landowners like ourselves own 76% of New Hampshire's total forest. Remember, good forest management is only one of the many benefits private forest landowners provide to our state. Good forestry brings into our state $1.4 billion and has nearly 7,400 workers employed in the forest products industry. Sustainable forestry also adds to our tourism and recreational industries. One example would be snowmobiling, which brings in annually, direct and indirect, over $600 million. They may be a little short this year unless we get some snow. Because forest landowners continue to open and share our forest lands and trails, which we built for forestry, 84% of the 7,200 miles trail system are on private forest land such as ours. As landowners, we want to continue sharing our land with our state agencies and the general public, but we would like the common courtesy of knowing if someone wants to place a game camera, a tree stand, or an observation blind on our private property. It is a very simple task for the hunter to ask the landowner for permission before placing a game camera, tree stand, or observation blind, especially if it will be left in place beyond hunting season. I encourage you to support and pass both Senate Bill 14 and 15, which will help all forest landowners feel better about sharing their land. I also have a few other comments that I have written in that letter that I'd like to share about game cameras and also deer stands on our property. We have one large tree farm which consists of 1,060 acres, which we give many tours on. We've given tours to the University of New Hampshire Thompson Forestry School for 18 years. Quebec Labrador Foundation, which is out of Massachusetts. They bring conservation folks from Eastern Europe, South America, and Central America. We've done that for more than 15 years. We have, my wife is concerned, as you've heard before, about out on that particular piece of property where we have found game cameras. When we have a family event or we're hiking on a trail or a special spot and nature calls, she wants to know, Tom, is there a camera around? And I can look around, but I can't honestly tell her that. When we're giving tours for, fourth, fifth, sixth grade kids, which we do a lot of, I don't want the responsibility of those kids being cameraed and then show up on Facebook and I get a call from the parents or the school system. And we do all of this.
That's a good point.
As far as the snowmobiling or the tours, we do that at no cost. We're not asking for anything. We're only asking for the common courtesy of getting permission for those three things that are in the two different bills. The other thing that I fear as a landowner, and I know many landowners have the same feeling, is liability. I worked all my life. I bought my first woodlot at age 11 to accumulate 2,800 acres of forest land, and I don't want to lose it. I don't want to lose it because someone comes into on my property to put a deer stand up, and let's say they're somewhere around my age, and they probably shouldn't be climbing trees, and they fall out of the tree. We saw what happened a few years ago just outside of Concord, where a gentleman fell out of the tree stand. He didn't get permission from the landowner. It was there, the stand was there. He just crawled up in it and fell out of it. And 2 months later, he gets the farmer gets a certified letter from a law firm that he's being sued. And Jason Sock can give you the, blow by blow on that. But what happened was it cost him around $9,000 just to defend himself. And that's wrong. And I think that needs to be addressed. I've also added a couple documents just to give you a little bit background on myself. It was in 2006. Fish and Game put out for the very first time commission awards. And we were honored to receive that award, the very first award, for going above and beyond as far as the landowner opening and sharing our land. 2 years earlier, and you'll have these documents, in 2004, the New Hampshire Division of Parks and Recreation, through the Bureau of Trails, came out with the very first award, which we were recognized for opening and sharing our land for snowmobiling and recognizing how important it is for this state. I've had a little experience in it. know, there's been a lot that's been said about the game cameras and stands. And, you know, I know there are a lot of hunters out there that just, they want to get in the woods and hunt, and they don't care how they do it. There are a lot of hunters that we've had over the years that always come and ask permission. I'd make it a point to allow them. I'm very careful as to how many I put in a certain area because I don't want any accidents. But to those that don't think they need to get permission from a private landowner, I would ask them, do you mind if we put up a game camera in your backyard?
Right.
Or maybe a deer stand in one of the few trees you have on your property? Or perhaps a blind on your front lawn? And we all, I think, can know the answer. It's no. So whether I have 2,800 acres or whether I have 2 acres, those are my acres, my family's, and we've worked very, very hard for that. I'm open. I don't post and have not posted, other than going through the Fish and Game, utilizing their posters for safety zones. I put them around the fields that we're working in. I put them around the buildings that we're working at. Other than that, I don't post. And I want to keep it that way. I can tell you on the dirt road that I live on, we have 650 acres there. The farm before us, which was just recently sold, 300 acres, is posted. The farm above us that was sold 6 years ago is 250 acres, is posted. And that's what's happening. It's not only in the southern part of the state, it's moving up this way. And it's a different mentality. I think a lot of these people are coming from out of state, and the first thing they get it, you know, their dream property, and they post it, and it's off. And I don't want to do that, and I'll work with the Fish and Game over and over to not to do that, and I'll work with the state of New Hampshire also. Thank you very much.
Questions from the committee? Seeing none, thank you very much.
Thank you.
And our last speaker is Susan. Is it Priyu? Right. Of course.
My former seatmate.
All right. Welcome, and thank you for your service.
Thank you, Senator. Thanks to Senator Water for sponsoring the bill. I'm the Fish and Game Commissioner for Carroll County, and I'm also the Legislative Committee Chair. I think the bill, as introduced, is an example of how all the stakeholders got together and tried to come up with a solution. We're often criticized at the Commission and the Department not doing this. Mm-hmm. And I think this serves as a good example of how we had input from all the major stakeholders. We also listened to the testimony last year, the issues, and I think we have a workaround. You've heard a lot from the private landowners. I have observed what Mr. Thompson's observing. I live over by Castle in the Clouds. I'll be honest, we had to post our land, not because of hunters. We're near a trailhead, and we had people coming on our property looking to do things like source chaga off our white birch trees. We found garbage. This was not hunters. These were people using the trails by the Castle in the Clouds area. So I do admit I'm a Fish and Game Commissioner, and out of concern for our own land, we posted. We're looking at a workaround with that, similar to what other private landowners have done, but it is a concern. My concern with the amendment is a good example of my driveway. If we unpost, I have a 500-foot driveway. Anyone could easily put a camera at the end of that driveway and figure out our comings and goings. Right. So that's a very big concern for someone such as myself. Your home is not always right on the road. We have had some unfortunate, very bad examples of, for lack of a better word, perversions. People intentionally taking pictures that are wholly inappropriate of adults, children, you name it. The one that comes to mind is over 20 years old. There was a gentleman that was arrested, and perhaps the colonel remembers this. I believe it was in the White Mountain National Forest, somewhere along the Kangamangas. There was a gentleman that, you remember? He took a camera, went down into the women's pit toilet.
Oh my gosh.
And fastened this camera somehow, and I don't think I need to continue. So we're also concerned about people that aren't hunters doing this. The continual posting, we actually had a positive thing in Tuftonboro where a family came in from out of state, bought the land and the house. Most of the 200 acres was in current use. They posted. And they also posted around a historic cemetery. It was nothing like seeing your family's loved ones with bright orange no trespassing signs behind the headstones. So I and a couple other people in the area waited till they came to town and just went and explained why it was important not to post your land. I also informed them that if they did not allow beaver trapping, approximately 45 acres of that land would flood every year. So they would be looking at 25% of their land loss being inundated with water. So a lot of that is this personal outreach, and that's something the commissioners, we frequently do. But I think this is a good piece of legislation as written. Like I said, we learned our lessons from last year, and we did bring the stakeholders together. And you're never going to make everybody happy. We all know that. Everybody in this room knows that. So we do think this is a good bill, and we hope that it moves on to the House in its original condition. And I will go on the record, because I was here last year, the deer I got this year did not show up on my game cam. I come from a long line of hunters, and well before game cams, I'm here to testify, you do not need a game cam to get a nice 10-point buck. So.
Are you bragging?
I have to. But I will say that Commissioner DeBow of Grafton County, my deer was only 150. He landed a 210-pound.
Wow.
Yes, it was quite large. So I'd be happy to take any questions.
Thank you for your testimony, and any questions from the committee? Seeing none, thank you very much, and we're going to close the hearing on SB 14 and move to SB 15. You want to exec?
I don't care.
Do we get SB 15 today?
Yes.
Yeah, let's.
You want to do that first?
Oh, we have another one.
Yeah, we have another one.
Tree stand.
Yeah. We got a lot of speakers on this one. Do you want to? Do you feel like you want to exec before we get into this one?
No,
or?
let's go to the next
Okay.
bill.
All right, you're up.
No, I'm up.
No,
Oh, you're
it's-
up. Jeez, I thought it was all you today. All right, you're done. All right.
The seat of heat goes to Senator Pearl.
All right. So if we can get this done before 12 o'clock, we can definitely do some execing. So I know.
Whatever.
Not that I'm going to hurry anybody, but we would like to exec a few bills. So with that, we recognize Senator Howard Pearl to introduce SB 15.
Thank you, Mr. Chair. It's my first time testifying before the committee I now sit on and as a senator, and thank you, I appreciate it. For the record, my name is Howard Pearl. I'm the senator from District 17. So I'm here to introduce Senate Bill 15. Excuse me. A few points that I'll make about the bill. This will provide clarity on, the bill is introduced, will provide clarity on permanent tree stands and require written permission from the landowner. The current language does not differentiate between permanent or temporary tree stands. Secondly, it will provide timeframes for erecting portable tree stands. If a property owner permits hunting on their land, temporary tree stands are allowed without the need for written permission between August 1st and December 31st. Finally, it'll add a new requirement for the labeling of tree stands. All the tree stands will be required to have the name and contact information of the tree stand owner in the event an issue arises that needs to be addressed. This bill came from a similar bill last session, House Bill 490. That bill died in committee of conference, and we're hopeful that this bill will not suffer the same fate. So I did prepare an amendment, and Senator Waters might note that I have 002, which is one in front of his 003, so I got in one in front of you. And the reason I prepared this amendment before I talk about it is that there's been concern raised about the removal of the tree stands after the season, but prior to the January 1st date. There was some concern raised about inclement weather and, the age of some of the hunters that might provide difficulty with the temperate conditions we have here in New Hampshire. And so I think what I felt was the most important part of the bill was getting the names on the tree stands so that we knew what was going on. We knew I'm a large landowner myself, well, not compared to some, but I've around 300 acres. And, it is a lot of area to cover, and we sometimes do forestry operations, and we do find these tree stands around. Now, I have the good fortune that most of my land is in maple orchard. It's not real desirable for hunting because there's a real large infrastructure of the maple equipment in there. And so it isn't as conducive for people to get around freely and put up these stands and do the hunting. But I certainly do understand the concerns that we've heard related to the last bill. The two are kind of sister bills. I'll leave the amendment out there. I've passed it out to you all. In hearing the testimony, I think we could probably change this even a little bit more. And I think we might need to have an additional amendment done. But what this amendment would do is it will keeps the clarifications that I talked about in the original bill. It just removes the requirement to take the tree stand out and to get written permission. I'm not sure now that that's the best choice as we go forward, because I have heard a lot of testimony, and I've been listening to it, and listen to, I agree completely. Being a landowner, you have rights. Hunting is a privilege, and we need to respect that and make sure we keep them in the correct hierarchy as we consider these bills. So I'm going to stop there, and I'm going to let the folks behind me do a lot more testimony, and talk about the things that I want to. So.
Thank you, Senator. No questions? So we have a lot of people in favor. Absolutely nobody is opposed to this bill.
I'm sorry. Can I ask a question? I'm sorry about that.
Okay. Senator Waters.
So, thank you, Senator. In looking at the original bill, that's Section 5, which you then have deleted in the amendment.
There we go.
It's on the temporary reportables.
Yes.
So I guess my question would be here is that if you don't have a provision for their removal, then they become permanent.
Well, not by definition, they don't.
Well, but you see what I'm saying?
Yes, I do. I understand. The definition of permanent is different. It's fastened securely to the tree with, hooking in and lagging into the tree. At least I'll look at Colonel Jordan perhaps to correct me if I'm wrong on that.
That's an interesting concept.
Yes.
Yeah, I mean, I just wondered what you thought about that. If something's up there and it's going to stay there forever, it may be, it may have been constructed as a portable or temporary stand, but
sure.
But there it is on somebody's property, and that might raise the same issues about timber operations or whatever we've heard about the permanent one. So I just wonder if there's a way to kind of say that we have a definition of a temporary stand, which means it may be erected for no longer than or something.
I'll give you my personal opinion from having used these. More of the concern would be for the safety of the hunter returning the next year, because most of these are hooked in with some type of strap.
Yeah.
And hopefully everyone is doing their due diligence and checking on these before they climb into them. But it may be another hunter that's climbing into them.
Right.
And obviously that's a terrible idea, and they have to have that liability themselves when they go into something that's not theirs. But my experience, at least with this, is if you leave these temporary stands the way that most are fastened, they will eventually come down on their own. And that just then creates a situation for the landowner that he has some cleanup that he may not want. That's the part I don't like about it. you know, when I was looking at this amendment, I was trying to strike a balance in the middle somewhere that still allowed the hunters these privileges without creating, you know, too much of a burden on them. But I certainly understand the landowner aspect of this as well, and so it's something we need to think a little bit more about. Thank you for the question.
So for my clarification, are we leaving it in or taking it out?
Well, I've introduced the amendment. I think it's some. I heard you. I don't know if the others did.
They didn't.
I've introduced the amendment. I've certainly put it out there. I think it may be something that we want to have a little discussion on before we exec it. And maybe if we could not exec it today, it might be a better choice, that we could have a little more thought on it. But I'm going to leave that to the discretion of the chair.
All right. If we can fix it today, we can fix it today too. So,
Sure.
That being said, thank you very much for your testimony.
Thank you.
So like I said, there's nobody in opposition to this bill, which means the clock is on our side if you want us to get this done today. Otherwise, you can testify, and I'll just call up your name. If you want to get up and give a brief hello, that'd be great. So Colonel Jordan, we'd love to have you come up and testify.
I think there's a couple of important pieces. This is, again, good morning, and this is the reason I like this committee, is because you do have open minds, and I appreciate that thought process. That's kind of important, and we don't always see that. But we do in this committee. So 207-36A, I want to draw your attention to that. So that is the tree stand existing law that is on the books today. And it describes in paragraph 1, 2, and 3 what a permanent tree stand is. Basically, as Senator Pearl was referring to. And that description includes any insertion into the tree. So a ladder that's screwed into a tree, a nail for a 2x4 if you build a permanent stand, although that isn't as common anymore. Or a pit blind where you're digging a hole, where you're altering land or doing damage to a tree. It also covers, and this is where hunters cross the line, it also covers or prevents you from cutting so much as a branch of a tree. So hunters will put up a stand, they want to clear away, especially during bow season, so they get in their stand and they look around and they see a couple of softwood branches that are in their way, and they go down out of the stand and they cut those branches off. These are all complaints that we get from landowners, and all of what I've just described to you would require permission, written permission from the landowner. And a lot of landowners will give you that. I'll give you a perfect example. I returned to a deer stand last year on this open piece of property I was hunting on to find a business card on it. I was mortified. It was the landowner. And it said, please call me. So I immediately removed the stand because obviously there's a problem. He wouldn't have left me a card, and I went immediately to his home, much to his laughter, because no one had ever done that before. He was shocked. And I said, well, I want to hunt on your land, so I want to. And the problem was I had climbed into an ash tree, because an ash tree is very straight, very clean. You don't have to cut any branches. I had a climber, and it went up this tree, but it scratched it going up. It scratches the tree. So you don't require a permit for that because it's a temporary portable stand, but it scratched the bark, and he didn't like that. And so I said, what tree do you have a preference? And he said, yeah, I'd like you to be in a softwood tree. Can you do that? I said, I can go in any tree you want me to go in. That's the way I like to hunt, is in a tree, and I'll go wherever you tell me. And I said, the problem with the softwood, I have to cut branches. He said, no problem. I don't care about that. He said, I'll give you a permit for that. I just don't want you in my hardwood trees. It was a good example of what different landowners want. And if you're not asking permission for that, you don't know that. So that cleared up the issue, and I shot a nice buck out of that softwood tree this fall. In fact, Senator Pearl and I exchanged text messages when we're sitting in those stands. We're not that far apart. So I'm quite confident I shot his buck this year. Again, one of the major complaints that we get, the two complaints that we get routinely are these and you can see that from the testimony that you're hearing today behind me from the landowners. This is their issue, tree stands and cameras. And so the tree stand, the biggest complaint was, I don't know who it is. And a lot of hunters think that's required already, to put your name on it. It is not a requirement under this law. It would be if this bill were to pass. It's a simple request, and I think an important one. The second one, the one thing that I don't think many people are aware of, is we have two different kinds of lands in New Hampshire. So when you're talking about open lands, don't forget the state has a lot of land that we own, the state of New Hampshire owns. And so in the camera bill, the bill we just heard, we didn't put any requirements for cameras on state-owned land. So you can do whatever you want on state-owned land. We felt that was appropriate because it is state-owned by all of us. So we didn't include that. The tree stand piece of this, on state property, and I don't know when it came or why it came, but on state property, there is a requirement to remove the tree stand December 31st of each year. We find a lot of hunters crossing that line, and I know they cross it because they don't know why that is. It's confusing to them. It's something different from what they're used to, something in the law that I've seen. Every time we do that, we make criminals out of people who wouldn't necessarily be criminals. So when we were putting this bill in, we talked to the landowners about the removal part of it, and we felt that would be more consistent with existing rules on state-owned land. So no matter where you put a tree stand up, it would be consistent that your name would have to be on it and that you would have to remove it at the end of the season. And if it's a permanent stand, described very well in paragraphs 1, 2, and 3 under 20736, you need a permit. That doesn't change. If it's a portable stand, you do not. The other thing I put into this bill, because I wrote the language for this, the other thing that I put in this, thinking about hunters like myself, if you've got a landowner who doesn't care, we've put a provision in there. So if your landowner doesn't care about you taking it out and he's okay with you leaving it up, then leave it up. But it's the landowner's call, not yours. And the other major complaint I get, and I know you're going to hear it from Mr. Thompson and others behind us, is when they go to cut wood. You know, you'll see it. I just saw one the other day. You got a cut, and there'll be one tree standing, and if you look closely, there'll be a stand in it. And you got a logger or a jobber who didn't want to cut that tree down to do damage to that stand, and no one knows, including me, who owns it. There's no way of telling who owns that stand. The argument that I've heard is, you know, it's difficult to remove in January. I would agree. That's why I removed mine in November. I shoot a deer, I go in the next day, and I get my stand and my material, and I get out of there. I know why hunters don't want to do that. I get it. They want to leave that up because that's their personal area to hunt. I get all of that. But you're forgetting the important piece with both the camera and this, that it's the landowner that we should be worried about, not the other hunter. You can get in there early and set it up, and if your landowner is willing to forego any of those dates, you can do whatever you can do what you're doing now. You could leave it the way it is now. You can put it up in June and leave it until next June if the landowner's good with it. So if the landowner isn't, you're required to remove it. And we've got people putting up stands all winter to coyote hunt, because you can't do that until winter time. So there's people putting those stands up in the winter time. It's a little more difficult, I agree, but it's not impossible.
Would it be helpful if on line 12 we just added and temporary stands getting written permission?
I didn't want to do that because that's a requirement we've never required in New Hampshire for that. I don't know what anyone's thought is on that. We've never required a written permission for portable stands. I think we'd get some pushback from hunters for that. But again, I think it's important that we recognize and respect, you know, the landowner. I mean, you're hearing good testimony behind you. These are the people that I talk to on the phone. You know, they're reasonable requests.
Yeah.
So
questions from the committee? Seeing none, thank you very much, Colonel.
Thank you very much.
So a lot of the testimony from the previous bill was well received, and just curious, does anybody want to talk on this one? If not, we can move forward. We have a hand up. Come on up.
Thank you. I'll make it brief.
Yep. And I know you're on here. Let's see. You're Walt?
Mark Ledgar.
Close. It was Mark. There it is. Right next to Walt.
Thank you. So I own land. I have my own tree stands on my land. I have friends that are putting tree stands. I give permission to probably at least 10 other people. It's a 40-acre lot, so I kind of limit the area. Personally, from my experience, I found it more difficult to put a tree stand up than it was to take it down. And the reason is when you go to put your tree stand up, you don't have a lot of that safety equipment already up there. You have to have your climbing ropes. It's harder to get it up there. Once you're up there and you get all your safety equipment up, taking that tree stand down actually is easier. I've come up with an approach, which I haven't done it yet. I'm going to apply it. But actually, you can put a pulley up, and you lower it by rope. Usually it takes a friend of mine to help me do this stuff. So I find that that's just as easy or easier to take it down than put it up. You got to carry it in and out of the woods. All that is pretty much the same amount of effort. There's a local farm that just recently posted their land because when they were walking the land, they found a lot of tree stands out there. They didn't have any contact information. Well, they posted it hunting by permission only. I've hunted it, I know the people for years. The tree stands did not have any contact information on them. So they didn't know how to contact those people. Taking them down would have been illegal, or calling Fish and Game. In one instance, I referred a landowner to call the local conservation officer to come and help resolve the issue. And I think that's about it.
Well, what if you put a game camera right in front of that?
You have to see.
Would that help you find out?
We could do that.
It's your land. So, questions from the committee? Message well received.
Thank you.
Does anybody else want to?
One very brief suggestion, and for the record, once again, I'm Jay Finzi, and I've seen a bunch of tree stands left unattended.
Could you sit down while you're talking? Yeah.
Sorry. I've seen a bunch of tree stands left unattended in the Ackworth area, and I think that it's not only damages the tree, but it tends to be a liability.
Right.
Blah, 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 blah. Anyway, what I would suggest is if you look at line on page, and with all due respect to the colonel, I would change the language dealing with the violation, and that's number 9. Any person who violates any provision of this section shall be guilty of a violation and shall be liable for the amount of damage caused by the act to be recovered by the property owner sustaining the damage. I would actually make that a little bit more uniform, and I would recommend something along the lines of any person who violates this section shall be guilty of a violation and subject to a fine of up to $1,000 for each offense. And the reason I say up to $1,000 is I keep it standardized with the other bill, Senate Bill 14. And such administrative fines as a result shall constitute an acknowledgement by that person who has violated the provisions of this section and shall be liable for all costs of recovery by the property owner. And the reason I suggest that is that, in essence, if someone's coming to ask for permission, and if they're essentially putting a hunting stand up, they should actually be aware of just exactly all the rules. And if they aren't aware of all the rules, then they should be subjected to a fine. And why would the landowner need to have to go to court in order to recover this? Because, you see, part of the problem is, and one of the things that I found annoying, and this was just recently with the snowmobile trail that I have, regardless of the fact that individuals, and this is somewhat the same point, but regardless of the fact that individuals are only supposed to snowmobile on that, and I let the trail people post the things like no motorcycles, no whatevers, this, that, and the other, is that in essence, the landowner now has to go to court in order to resolve the issue. And going to court, that landowner has to spend the money.
Right.
And so what I'm looking for is potential acknowledgement that I understand the rules, and I understand the rules proposed by Fish and Game, and I can be subject to a fine of up to $1,000, which is consistent only with general statute anyway. So that would be the...
You got that, Nick?
Yeah,
I
could send you a email if you give me the email address. Now, I don't know whether that's legal or not, or whether it's acceptable law practice, but
yeah,
run it up the flagpole and see if anyone salutes.
Okay. Senator.
Thank you. Jay, so what you're suggesting is, well, it's the old section 8, or no, excuse me, gotta get my Roman numerals. The new section 9.
Yes, exactly.
You'd be swapping that out for the language that's in Senate Bill 14.
Pretty much the language, with the addition that by someone seeking the permission and getting a permit or acceptance by the landowner, that they acknowledge that they have to comply with the statutory requirements.
So the only concern I have with that is we're not requiring a permit or even requiring landowner permission to put a temporary tree stand up.
Well, that's something you have to figure out, because there was a question about Eric Sawtelle.
But I mean, the way the bill is written,
Yeah.
as introduced, we're not even requiring that permission.
Yeah.
The only thing we're requiring them to do is take it out by that certain day.
Yeah, this is why I may need a little bit more work. I'm just very concerned. Eric Sawtelle did bring up on that one meeting that we covered this as well. Eric Sawtelle brought up just exactly this temporary stand issue.
Mm-hmm.
Yeah.
Thank you.
So thank you. What I'll do is, if you want, I'll be glad to forward this to you. And I have to say, I really appreciate the Colonel's appreciation of the landowner. I think it's just, it's high time that that's been recognized. So my appreciation for the Colonel.
Thank you very much. Anybody else? Jason?
I'll be quick. I guess I just wanted to put a couple things in context on this bill. For the record, Jason Stock, New Hampshire Timberland Owners Association. And we support the bill as drafted, simply. And as does Farm Bureau. And we were both parts of a coalition that drafted this bill. It was a coalition with the Fish and Game Department, Wildlife Federation, TOA, and the Farm Bureau. And there were concessions made on this. We have a balanced bill here. We start removing requirements out of it, or, that, as you all know, this is the world you live in. We need to go back and take a look at it. But right now, we have a bill that strikes a balance. We made a concession on this. I had members that felt strongly, just like the camera bill, you're putting a piece of personal property on my private property. You can at least afford me the courtesy of a heads up and require permission. And so we said, all right, for temporary stands, we won't go there. Permanent stands, pit blinds, keep that. But for temporary stands, so that was a huge concession to remove that section out and to say you no longer have to get permission if you're going to leave it up beyond December 31st. That's a problem for us, and I've been texting Rob, that's a problem for Farm Bureau.
Okay.
If you're going to leave a stand up beyond the hunting season, and Senator Waters hit the nail on the head, at what point does that stand become permanent? If it's out there after hunting season, in our mind, you start to drift into the realm of permanent. Even if it's a little metal platform with a rope and cable on it, you start to drift into that, okay, it doesn't pass the straight face test. It now becomes a permanent stand. So again, I would welcome the opportunity, if you're not going to exec this today, to be a part of any discussions on this. But again, for us, this is kind of comes back to a lot of the courtesy and property issues. And I haven't seen the amendment. I'm just speaking from what I've heard. So I'd be happy to try to answer any questions.
Questions from the committee? Seeing none.
Thank you.
You're welcome to.
Tom Thompson again. I'll be brief.
Oh, okay.
I do agree with Jason Stock. We talked about it, and even with the temporary stands, which I believe they can put in without permission, but what I want to clarify, does that stand have to have their name and address on it? Yes. Okay. That's a huge issue for me, is finding a stand and not having any idea who the heck it is. The other thing I'd like to point out is the damage. We had a logging operation last year. We cut a 2.5, or the logger did, in 2.5 diameter ash tree, brought it out onto the landing. In the process of cutting it up into logs, fortunately they didn't hit one of the large spikes in there, and we found those before it went off to the sawmill. But this is the kind of liability. Forget about, it was probably 600 board feet of ash that we lost out of that. Forget about that. The liability issue haunts many landowners, and I just bring that up. That's going on out there, and I want to support this. I do support it the way it's written right now, and maybe hopefully come back. Let's see how it works, because in my heart, I believe that anyone that puts a stand up on your property should have the courtesy to go to you and ask and get written permission.
Thank you.
Thank you.
Stephen?
Sorry, still Stephen Wood, still living in Plainfield, same old acreage.
You haven't changed.
Something's changed pretty fast there. But I regret that my two organizations made those concessions, folks. Those two concessions, that is, I mean, I honor them for doing it and for doing the pragmatical thing in order to get something going to cure an appalling state law, and I honor you for doing that. But I'm not going to say the same things I said last time about private property rights. This should be, I mean, paragraph 5, or 4, I'm sorry, the you just take away the word permanent and you're all set. Don't put up a tree stand without permission. Now, my way around this right now is interpreting the language on our hunting by permission only side. It's a part of the permission. And that's the way the people who come to us and ask permission treat it. Then we've given, again, a lot of people permission to hunt in tree stands. They ask. And it is hunters and snowmobilers, I didn't say last time, but we also, on specific trails, allow snowmobiles and snowmobile clubs. They are also very good stewards of the land. They're the ones who come tell us about stands that they don't think should be there. Half the time we don't even see them. Mm-hmm. But when they come for permission, if they want to put up a stand, I don't think, since we've been insisting on permission, I don't think I've seen a stand in the woods that hasn't already been asked. I mean, I'm talking about the little temporary stands as well. And it strikes me that well, let's see, I hope you will pass this on as introduced, but I regret that it still is, to me, it represents a bit of an abrogation of private property rights.
So your preference would be just get rid of the word permanent?
Get rid of the word permanent and just require permission for tree stands.
Okay.
Don't surprise a landowner with some observation deck in his tree. And I can also, I talked to a couple of landowners, well, I told you I talked to quite a few landowners. A couple of landowners who, when I told them this law actually was the law that this addresses was on the books, said, oh, I mean, I don't think they're going to do it, but it's like, all right, post my land. But this is what's going to happen. I mean, I didn't know this law existed. People, I don't want to see more posted land. But you can go to landowners only so far.
Senator Pearl with a question. Do you have a question?
Sorry. It's like, I'll wait, sir. I'll wait. I'm the one who's using up your time.
All right.
Okay.
Good.
Thank you again for everything.
I got Walt and Kyle and Daniel. Yes. All right, Walt. Bring it on. Come on.
I think I made myself clear first time around, but the tree stand issue, I think, is equally important. That's where I've had major problems.
Right.
I had a half a dozen tree stands. In 4 of them, they screwed up the trees, okay? I have 10 or 12 miles of trails on my property. Establishing a dialogue through somebody saying, hey, I want to put a tree stand up, well, where? Well, geez, that's a hike trail, we'll stay away from it, whatever. I think that's essential. Then it's how long it stays there. You get the dialogue going. I'd like to leave it here, through into the spring, whatever. But I agree that I feel very strongly that you put any gear on somebody else's property, you get permission, put your name on it. And I think the tree stands have been more of a problem for me physically because I found them than cameras, which are now coming into vogue. So I'd say get permission, 100%. Thank you.
Well received. Thank you. Anybody else? Matt?
Thank you, Senator. Good morning. I'm Matt Leahy. I'm the Public Policy Director for the Forest Society. I will be quick.
Thank you.
So the Forest Society, of course, we do own land in New Hampshire. We allow hunting on those properties. Our current public use policy, does allow for temporary tree stands, not permanent tree stands, but we do encourage people to label their tree stands. And we also ask that they remove the tree stands when hunting season's over. The challenge we have is trying to, enforce that. So having, the law as proposed would kind of help us, know who's out there in the woods, so we can manage, our lands better. Again, we do conduct timber harvest, so it's helpful just to know whose tree stand it is. So again, we support the bill and appreciate your time.
Thank you very much, Matt.
Yeah.
Any questions from the committee? Of course you do.
Thank you. Thanks for taking my question. So I'm just trying to make sure I clearly understand. So on the lands that you guys manage,
Yeah.
the state lands, do you already require the removal by December 31st?
We ask that they, yes, we ask that they be removed by the end of hunting season, but again, it's, we don't always know whose stands they are. So if we do find one that's, past its time, it's hard for us to know who to contact. So obviously having the labeling is probably the most important
So
thing
you're not
for us.
requiring labeling now on state lands?
Well, we don't own, we're a private organization.
All right.
So this is, again, we're a private landowner similar to the other
Got it.
landowners.
Sorry.
Yeah.
All right, my misunderstanding. Thank
Okay.
you.
Thank you very much. Kyle? All right. Daniel?
Real quick. I support 15 like I do 14. And I just want to say, as a sportsman and a landowner in the state of New Hampshire, that I believe we owe this to the landowners who give us the privilege to use their property. And so I hope that everybody will vote in favor of them. And I won't be any longer.
Questions from the committee? Thank you very much.
Okay.
Marty?
No, sir, I am not speaking.
All right, that's right, you were, no,
I said no.
that's good. I want to move forward with you. Seeing how, and nobody else wanting to speak, we're going to close the hearing. Is there a motion to move into exec? Is second, okay, all in favor? Any opposed? Seeing none. Thank you. So, let's start off with 11. Is there a motion on 11? I'll make block to pass.
Mr. Chair, where I wasn't present, could you just quickly give me, just give me a little, on what the amendment is?
We passed this bill in a slightly different version of it last year on consent and resources and recreation economic development in the House one. Asks Historical Society and other people to check out. If you got human remains from folks that you ought to, you ought to figure out a way to respectfully dispose of them. So.
Okay, thank you. That's all I need.
All right, further discussion.
Did we, where was the amendment?
It was a written amendment, just shall make
Okay.
reasonable.
Yeah, it
There's a committee.
shall make
That's right.
effort to
Okay.
inventory.
So, yeah, so,
Second.
as far as the amendment, yeah, I need a second.
Second.
Seconded by Senator Bertzel. All in favor of the amendment?
Aye.
Any opposed? Seeing none.
Ought to pass as amended.
Is there a second?
Second.
Seconded by Senator Bertzel. Discussion. All right, all in favor of passing as amended?
Aye.
Aye.
Any opposed? Seeing none.
I guess I'll take it out.
Senator Waters will take it out. Perfect. Beautiful. All right. So let's do 13.
I'll move on to pass for discussion.
Senator Waters moves SB 13, and seconded by Senator Pearl. Discussion.
So, it's an interesting issue in a way, in that the authority was granted to Fish and Game to request this suspension, but we didn't tie it up with legislation that lets the DMV do it. Now, as Senator Birdsall knows from transportation meetings, it's really kind of touchy to say to people that you might lose your ability to drive because that's your livelihood and so on. I respect that they're going to take that very carefully and deal with that only in circumstances where there is no alternative. Let me just note that there is a House bill that would outlaw anywhere in statute the ability to take somebody's license for a civil fine. So that will work its way out in the House. I don't know what's going to happen to it. You've heard my reservations, but I think Colonel Jordan and others make a reasonable argument. And if we're passing a new law that says, for the first time now we give you permission to do it, I think we'd have a different conversation. But since it's already there and it just DMV says, hey, look, we need it on our side to have the authorization, that's why the bill is here.
And also think about it, while I agree, surrendering the license to a certain point, however, it's almost as if these are habitual offenders and they refuse any other type of remuneration to the state. So I think this is kind of the last resort.
And I would agree. I think we heard in testimony from Colonel Jordan that they're not looking to this as their first line of offense here. This is a last-ditch effort that when they've exhausted all of their opportunities.
Okay. Further discussion? Seeing none, all in favor?
Aye.
Any opposed? Seeing none? Who would like to take this out, Senator Waters?
I guess I will.
All right, wonderful. Beautiful.
Okay.
And SB 14.
Is there an amendment on that one? No.
I don't think so.
Okay.
SB 14, is there a motion?
Well, I'll move on to pass.
Is there a second?
Second.
Senator Birdsall seconded first.
So, I'll maybe I'll defer to you, Senator Pearl, and see what this is a tough one, and so what do you think we ought to do?
So I think that, excuse me, we've heard an awful lot of compelling testimony today from many of the landowners that have taken the time out of their days to come here. I think I certainly understand that we want to make sure that hunting is accessible and it becomes, is a privilege that all can enjoy, or as many as possible. But we do have to have respect for our landowners. We certainly have to have respect for the situation that this puts our enforcement division in by some of the deficiencies that are in this law, and they're put in the middle with trying to, deal between the landowner and the complaints and certainly the will and wishes of the hunters to be able to use this new technology. I think it was, and I don't recall who said it in testimony, but we heard that it was, this is a situation where the law is catching up with technology, and I have to agree with that. 10 years ago, I didn't own a game camera. I never thought of hunting with one. They're very cool. I like them. They're fun. Can't say that they've really ever helped me harvest anything, but it does give me an idea of what's in the area, and I think that the hunters want and need the ability to use them, but I don't think it's an unreasonable request because of the privacy situation that does exist with them to ask that they just get permission of the land that they're using and to go forward with that, and make sure that everything is working in harmony as much as possible. I don't think that's an unreasonable request. I know on this bill and on Senate Bill 15 that we had looked at amendments. I think that maybe there's a thing or two we could tweak in these, but I think that we've got a pretty good bill, and I think we have an opportunity on the House side, if we have some concerns, that we can go work with them and we can, maybe make a small change or two if they're necessary. So I'd be comfortable right now passing this out as introduced.
Further discussion? Just my 2 cents. I do believe that this is a liberty issue where, without property rights and being respected, the whole concept of liberty is just academic and it's not real.
Yeah.
And so I completely understand and respect and want to honor the fact that this is your property and do as you please with it within, but everybody coming on the property, that's by permission. Now, unlike some of you out there, I only got like a quarter of an acre, right? So I'm just a little guy. But somebody putting their camera on on my property. I had a deer in Nashua on my property. So, I know I'm being a little silly, but I really strongly believe that, the fact that unless we respect the property rights, it really is just academic and nothing more.
Mm-hmm.
So with that, I vote in favor of that, and I hope my colleagues, we all agree on the same. So with that, no further discussion. All in favor?
Aye.
Any opposed? Seeing none.
So, Senator Purr, would you like to take this out? Because maybe you could speak to some of the conversations we had and anticipating the House conversation, because, but I mean, I'm happy to, but if you'd like to.
You want me to be the sacrificial?
No, I mean,
lamb?
I just wanted.
Hey, listen, it's
I know
pro-liberty
how
as
much
far
you-
as I'm concerned.
I know how much you've worked on it, and I just wanted to offer that if you like to. Otherwise, I'm fine to do it.
I will take this out, and I'll even preempt, I'll take 15 out too if we pass it, because they're kind of sister bills.
Good.
We'll do them
Good.
together.
Thank you.
Okay, so that's, Senator Pearl will take this one out. Now, let's do 15. Is there a motion?
I move out to pass.
Is there a second?
Second.
Seconded by Senator Waters. Discussion.
So I'm going to give you pretty much the same speech that I just gave you on Senate Bill 14.
It was a good one.
Yeah, it was good.
It was.
All ears.
Put that in the permanent journal.
The amendment that I tried to offer was to try to find some middle ground compromise because I want to see these move. The most important piece of both of these bills to me is getting the identification on the equipment.
Yeah.
And I certainly respect the landowner rights with the written permission. I think some of the landowners are going to find this may be a headache they don't want when they're trying to get written permission, but that's another bridge we're going to cross as we go forward. It may be a headache for them, but again, I think there could be a minor tweak or two to this that, we heard in testimony about perhaps changing the penalty portion of it. We can look at that. We can make some suggestions to the House, and if they move this bill forward in any different form, we could iron that out in a committee of conference. So I'm going to withdraw my amendment and just move it out to pass.
I would like to propose him. I like the idea of removing permanent. I do. I think it's in the spirit of the previous bill that we did, and I'd like if they want it, they can put it back in the House, and we can go back and forth on that. But just to be consistent, the word permanent on.
No, does that mean you would require permission for all tree stands?
Yeah.
I actually agree with you. I was going to say that. I mean, if it's going to put it in if it's going to put 15 in jeopardy, I'll agree to pass it as is. But I think anyone who wants to put any kind of tree stand on property, whether it's permanent or temporary, they should require it's someone else's property. They should be asking permission.
Yeah, I mean, why not put a lemonade stand?
If I may.
Without we can put anything on somebody's property, getting permission. Senator Waters.
Thank you, Mr. Chairman, and Senator Birdsall as well. I worry about going this far on this. I think the temporary tree stands and the hunters use them, it's a very different thing. And the question about do they damage the timber, well, they're just up there with a strap or other kind of affixing devices. And so they're much smaller, lighter, potentially. And I kind of worry about two things. First, that this comes forward to us from the coalition there after a lot of work. And you can be sure they debated all these things. And then secondly, I'm really, I think hunters are starting to get in a tough spot that if, sometimes you don't have to regulate absolutely everything. And that if if we haven't had a lot of complaints about the temporary ones, which I don't think we really have, and we're saying if you want to leave it up there longer, you get your permission for that, and that's fair enough. So I just feel hesitant about it. I really do, Mr. Chairman, and I think if we do that, I think we lose the bill.
And that's why I said,
Yeah, I
if
do
it puts it
think we
in
would.
jeopardy, I won't push it. I'd rather see it go through as is.
I might be reasoning wrong, but I mean, somebody could put in a temporary camera as well, you know, I just think the logic is the same, where we're still respecting the individual landowner's right, even whether it's temporary or permanent. And I do believe the discussion was brought up, well, what happens after, say, December 31st? What happens when it's January 1st? Is it now a permanent piece of property? And we.
That was referencing the amendment, in the
Right,
existing
so-
bill, it's taken care of, because it's gonna come down, but,
It's just, again, it's just a
the
respect.
context here is that somebody allows hunting in their land. And, you know, something might climb a tree and hunt from the tree, or they might have this little portable temporary stand that they haul up there, and so they have something to stand on and sit on, or just wait. Then they'll, you know, they may take it down, you know, they may take it down, or they may bring it back, but they'll get rid of it later on. And these things are not really intrusive.
But if somebody else climbs up it.
So, look,
Well, they're protected. The landowners are not protected from
if I
that
can
bill.
jump in
We
for a
dealt
minute
with
here.
that.
Some of these temporary stands we're talking about are called tree climbers.
Yeah.
You actually bring them in, you put them on that day, climb the tree, take them down, take them home with you that day as you go. Some of them are. So I'm not willing to go to the length that you're trying to go. I think the committee has done a good job on making a recommendation. While if that's something else we need to look at additionally in the future, I think we're making a big step here in getting, the biggest piece of this is the labeling again. And I'm pretty, I'm comfortable to go back to the original bill for now, even though but I would not be comfortable going further than that.
Well, and one of the things I would think about is move ahead with this one, and then come back next year and see if there are any issues with the temporary stands, and then deal with it then.
Bird in the hand. Okay, so all in favor of the bill as written?
Aye.
Aye.
Any opposed? Seeing none.
And I will take it out.
Senator
Pearl.
Pearl would like to take that out.
No, we wouldn't like to, he said he would.
Very good.
Move out of exec.
Seconded by
Second.
Senator Pearl. All in favor, say aye.
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 Any opposed? Seeing none. Thank you very much. And shut off your microphones.